28 CD receipt, na? Are they on entry?
Yes.
You are on entry.
Yes, sir.
To know whether we're going to retain the case diary or what.
See,
If we return back, may be difficult for getting the. It's saying 14 or 15. Either 14 or 15.
Obrigado.
14.
May I please, Your Lordship? May I please, Your Lordship? I wish to mention item number 19.
City receipt retain the till next day of posting. The matter of it. The interim department.
May I please, Your Lordship? In item number 23, I have filed objection my lord, as per this honorable court's direction. That record may
Did
be
you
taken
have
for my
already
lord.
filed your objection?
Yes, my lord.
Okay.
That may
See,
be good. Yes.
we'll see
Please, Your Lordship. Lordship, item number 36.
item number
36, Lordship.
36.
And Lordship, I have filed one affidavit, Lordship, and relevant paper was not annexed with the petition, Lordship, and that may be requisition may be called for.
Petition?
Affidavit.
Acha, affidavit.
Item number
In item
36,
number 36.
Lordship. May requisition.
Okay.
Lordship.
May I please? I beg to mention item number 19, madam. Matter may be adjourned for the day, madam. It is the 19. The leading
Receipt
count.
the scan copy here. Request made by another petition. Matter is that scan copy of the petition has already been received. But there is an office note. Is it a matter of POCSO or what?
No, madam. 109, 118.
Acha. Well, it 18th of this month.
Lordship. Obliged.
May it please your lordship, I beg to mention item number supply item 48, lordship. Kindly pass over the matter for the day, lordship, and kindly fix it on day after tomorrow, lordship.
Supply 48.
Supply
Supply 48. What is the position of what is the motion?
48, my lord. One report was called for, my lord.
Huh.
That report not yet received.
Not received.
Not yet.
Request made by another council for the petition. Raise agent for the day. Further, it is submitted by Mr. Godfrey that the report is also not received from the council petition. Reminder be issued. Let the matter when it can be listed. Because we have to call for the report again.
8 of
day after.
No,
on 12th,
we
13th
are
of,
not listing, ma'am.
13th of May.
Huh?
14th of May.
May I please,
14th of. Yes.
Mass of this.
may I please, your lordship? Lordship, I beg to mention item number 6, madam. Motion matter, madam. Kindly this matter may be adjourned for the day, madam, and pick the matter Monday, madam, 11th of May.
No.
Next week. Next week, madam.
The request made by another council. Raise agent. Yes. 15th of May.
May it please,
15th of May.
may it please your lordship. Lordship, I beg to mention item number 29, lordship. This is an anticipated bail application, lordship. Case diary was called for. This case was pending in the month of March, lordship. Lordship, can it be on next week, lordship? Because already, lordship, 1 month has gone, lordship. From 26/3
You are
last.
not an interim.
No, lordship, no interim, lordship. But they have, although 302, but they have settled the matter on because it's out of
302
electric.
cannot be settled.
Yeah. Out of
302
electric.
cannot be settled.
In
CD on 18th of May.
lordship, can it be shorter, lordship?
18th of May, man.
18th.
15th,
18th or
can it-
19th, any day.
15 can it be?
Shorter date means it has to come from.
shorter date-
Nogao, lordship, from
Shorter
Nogao.
date, 14th.
Oh,
Highly obliged.
May I please your lordship? I beg to mention item number 18. May it be kindly, it can be listed on next week, on 14th.
yes, what is the position of 18?
It is on interim.
18, my lord, case diary received, my lord. Final opinion regarding cause of death, everything received.
Only. So it is retained, then when it can be,
Uh,
when it can be listed.
My lord, any short date, my lord, next date, because in this matter, case of 1032 is there, my lord. I think on 13th or 12th.
Okay, 13th. The request made by land. Raise it. CD received. Retain the case date in length of listing. Estimate recording on 13th. They are not on interim. They are on interim. 13th of next Wednesday. It will be continued.
Lordship, sorry to come up again. Sorry, with respect to item number 19, there is an interim, Your Lordship. Interim may be continued, my.
Item number 19.
Yes, my.
Interim was there.
Yes,
Item number 19. Portion of scan copy. Interim be continued till later.
obliged.
Case of 69. He is in custody since 24/04.
Yes,
We are listing on next week.
yes.
None appears on call for liberation. Estimate accordingly. Date dito. PA to check. It's not.
May it please your lordship. Here, non-affair case lordship, this, on apprehension, they have filed this case and your lordship was pleased to protect them and with a direction to the learned PP to obtain instruction whether any affair has been registered or not.
Instruction, my lord, received regarding the present, against the present petitioners, both in Jalukbari PS and my lord, and all women police are one.
Item number 35 is also connected, lordship, regarding same petitioners.
1 and 35.
Yes.
35 also, my lord, on report is.
1 is in connection with
All women.
all women.
All women. We have the inquiry for the
As per all women, they have submitted the report that it has come to their knowledge, though inquiry was initiated. But subsequently, it has come to the matter is also inquired by Jalukbari OP. So in that case, all women police station, they have not registered any case against you. Now let us see. To look up.
This is regarding
If they are not continuing any inquiry, then in that case, lordship can close this matter. If they are not inquiring.
Because they have come to know that Jalukbari has already
No.
done this. That's why. And heard Mr. A. Ahmed did an consequent petition. Also heard Mr. P. Bott done an additional state respondent. The report received from all women police station whereby it stated that
report to did you?
initially inquiry was initiated in all women police station on the basis of a complaint by one Manju Begum, but when it has subsequently it has come to the knowledge of the concerned police station, that matter is same matter is also inquired by Jalukbari police station. In view of this, they have till date no case has been registered against. Considering the report submitted by officer in charge all women police station, present interrogatory application stands disposed.
May I pay for
Interim stands disposed and the interim stands. Petitioner would be at liberty to approach the appropriate forum in the event of registering any case against it. Further, the report received from the concerned police station will be kept and will be taken. Yes, what do you want?
may I pay for adding one observation, lordship, that if no case is registered, they may not be harassed, lordship.
My lord,
Because-
35.
35. What is the 35? Yes.
35 also the report received regarding this order passed in 35.
No, then 1 to 7, all women.
35, the report is. That I don't know. They have submitted that all women is is their view that they have already, Jalukbari has already initiated? No, this is again from all women.
Oh, sorry, my lord.
Other one is also from all women, and this is also from all women.
All women, yes. Then from
Jalukbari you have not given.
Jalukbari, no. They have wrongly, my lord, again, yes.
Yes, 2 reports have been received.
Regarding Jalukbari, not yet received.
Not yet.
No.
Report from had Mr. A. So had Mr. P. Potter put Ilanit edition. It is submitted by Mr. Botaput. No report has been received from Jalukbari PS. View of this, let the reminder be issued, directing the police, the officer in charge of the Jalukbari police station to submit a report on or before next date of this. When it can be listed?
My lord, on 14th of May.
14th?
14th.
14th of May, so hence interim be continued.
Obliged, Lordship.
Please, your lordship.
Yes.
Lordship, I'm paying for anticipated bail, my lordship.
Right.
Lordship, actually what happened, in this case, lordship, the complainant, namely Manish Basfar, who filed a false FIR in the police station, lordship, the complainant took an amount from this petitioner of 1 lakh rupees on
Okay,
11th
where
of
is the
March.
FIR? Where is the FIR?
No, there is no FIR has been registered yet, my lord. My lord, actually what happened, I'm telling you, my lord. Actually what happened, the complainant took an amount of 1 lakh rupees on 11th of March from the complainant, from the petitioner, and an agreement was also executed between them, and he also issued a check in the name of the petitioner, and the condition was that if the complainant could not return the amount before the 21st of March, he can bounce the check, putting the double amount in it. And my lord, after 21st of March, when the complainant could not return the amount, the petitioner threatened him that he will bounce the check and he will put the amount double. And my lord, on 9th of April,
Your
the-
petitioner threatened the complaint.
no, not threatened the complaint, that he warned the complainant that I will bounce your check because you could not repay the amount, my lord. And-
You will ask for double the amount.
No, it was the condition mentioned in the agreement.
Oh,
my-
the agreement
Agreement,
itself is
yes.
illegal. That means.
Agreement
Yes.
itself is-
And
Agreement itself is illegal. You
No,
cannot ask
it
for
was-
double the amount.
no, it
It
was
is the
my lord,
code. It can be. But
my lord, it was written in the agreement by the complainant party, my lord, by the complainant himself, my lord. And my lord, on 9th of April, the complainant himself called the petitioner to his rented residence to discuss about the matter. And when the petitioner and his bodyguard went to his residence,
petitioner goes with his bodyguard.
as with his bodyguard, went to his rented residence,
What he do? Your petitioner.
my lord,
What he do? Your petitioner.
petitioner is a businessman, my lord, businessman.
But why he need the bodyguard?
And he, my lord, he needs the bodyguard because of he got the bodyguard from the police station also because they took the threatening from like some unknown
Yes,
person.
person.
Yes. And
Oh,
my lord, on 9th of April, when the complainant called the petitioner to his rented residence, he went to his rented residence to discuss about the matter. And that time, the landlord of the complainant, namely Sanjeev Chakraborty, he assaulted the petitioner and his bodyguard just to wrongly parking the vehicle and without their permission, my lord. And
so there is no use of bodyguard.
yeah, my lord. And my lord, when the landlord assaulted the bodyguard of the petitioner took him to the hospital. And that time, the complainant Manish Basfar and the landlord Sanjeev Chakraborty went to the police station and filed a false complaint against this petitioner. And after that, the police went to his residence to arrest him. But today, almost 1 month, and police has not registered any FIR till date. But police went to his residence to arrest him. And my lord, now I'm praying for an interim relief, my lord. So that I can,
This is not a case of any interim.
no, my lord, that I can
Your
appear before the
submission
police
itself
station. That
is
my
a
lord,
very
my lord, that I can prove my innocence, my lord.
you can. We call for a report, obviously.
But my lord, just till date the CD, I can. Like-
He has bodyguard also. No issue.
Yes, my lord.
But my
Police
lord,
cannot do
till
anything.
the date of CD, my lord, kindly, my lord, my lord, grant an interim relief, my lord.
No. You are Mr.
J. Abbasi, my lord.
heard Mr. J. Abbasi, the learned counsel for the petition. Also heard Mr. P. Borkaku, the learned additional PP. This is an application for 82 PNS being practiced review with an anticipation of registering any case. Under which police station?
Tahsil Ambari Police Station.
Under Prohibited Ambari police station. It's subject that the police is searching for him. After assaulting the present petitioner and his bodyguard, and if it falls allegation and complaint has been made before police station. However, till date, he has no information in regards to registration of the case against him. Next one, Mr. Waterford, the learned counsel for the learned Muslim people submitted in this report may be called for from the concerned police station as to whether any case has been registered against the present complainant in under Authorised later the report be called for from the Authorised police station. Say additional people included in it. Yes, if a short they are not on
On 14/5,
14.5 will do.
It's too late, my lord.
12/5.
12, my lord. Plus, my lord.
It's
Your Lordship, so kindly please Lordship, here page 9 Lordship, translate copy, Barnacle page 30.
page 9.
Yes, Lordship, translate copy Lordship.
Yes.
Case of murder, 1031.
Daughter of the informed committers which are in her own home Lordship, and for the another home Lordship. They are the brothers in relation Lordship. It's a family case.
12 years old girl committed suicide.
It's own home Lordship.
No, what if own home? It's okay.
But case is registered under section
Under 103,
1031, man. This is submission only.
Yes, what is your case?
Lordship, we are the brother in relation Lordship. Petitioner number 1 and the informer are the own brother Lordship. They are the long-running land dispute Lordship.
Petitioner number 1 and
One and the informant Lordship. Own brother.
they are brothers.
Yes, Lord.
Achha.
Own brother. And the victim is the daughter of the informant Lordship. She committed suicide in her own home Lordship. But
In-
case is registered under section 103, section 1 in murder section Lordship. So we may be protected, we are ready to cooperate Lordship. There's absolutely nothing Lordship can be the affair Lordship. So it is clearly case of suicide Lordship. She committed suicide in her own home Lordship. We are sitting in another home
as
Lordship.
per you, why she committed suicide? She's merely a 12-year-old
Minor
Child.
she is only 12 years.
child. She
Child Lordship, only 12
Ah.
years. As per my
why
information,
she committed suicide?
as per my information, her father tortured her, assaulted her in many ways. As per my
Married.
yes, on many days.
Whom?
Her own father, the informant, within informant.
Own father?
Yes, permanent
Saying
assaulted her.
Huh?
Assaulted her on many days.
Assaulted her for what?
Informant not paid value.
See,
No, she-
question. See,
Yes.
because you are in a relation.
Yes,
As
yes.
you are maybe the uncle of the deceased.
So you are the uncle of the deceased.
Uncle of the deceased.
Uncle
So
and
against you,
cousin and-
but the FIR is lodged with the allegation of the murder. And that too, the girl is only 12 years old.
Yes, only 12 years.
A minor child. She committed suicide in a such way.
And she was
Now,
what we
why
did.
is there any reason? Is there any
Yes.
love? There is nothing.
We don't know the social relation.
Okay, we are calling for a case that. Sorry, it is not a case for and interview. Yes.
From Kamalpur, she shorted to be given. From Kamalpur.
Yes, for Thakur, when it can be called.
My lord, 21/5, 19/5, man.
Lordship shorted to be given. From Kamalpur, Lordship, Kamrup. On team is there. Today is 6, Lordship.
On 15/5.
Yes, Lordship. Oblast.
City. Yes, for.
May I please your lordship? This may not create bail application, my lord. The FIR is at page 9.
Yes, 9.
Page 9, my lord.
Mm.
The petitioner, my lord, he is having a travel agency, my lord.
and the informant is brother, is friend, my lord. He has a car. His vehicle was rented to the travel agency. And thereafter, we have, my lord, rented to third party by an agreement, my lord, page 14. Page 16, my lord, for 10 days.
Hmm?
And during this period, my lord, GPS tracking is disconnected of the vehicle. So immediately we file an FIR. Page, my lord, 19. The travel agency, my lord, the petitioner, he filed an FIR. And subsequently, the owner also filed this FIR, page 10, page 9.
You are the driver.
No, I am the travel agent. I have travel agency, man.
So who disconnected the GPS connection? Who disconnected the GPS
The
connection?
third party who taken the vehicle from us, my lord, they disconnected. And thereafter, police, my lord, asked the petitioner to appear. He appeared and produced all document. His statement was recorded. Now case has been registered, my lord, so I am pending that he may be arrested.
You are basically the agency.
Lost. I will cooperate with the investigation, my lord.
Ask my friend means who is you? Who are you?
Lordship.
Friend means who?
Ariful Islam is the petitioner.
No.
He took the vehicle of the informant, my lord, on rent.
But
I have paid all his amount, my lord, page 18 onwards, my lord. One Asiruddin, my lord, he has taken vehicle from us for 10 days by executing an agreement, page 16.
who is the friend of the informant? I asked my friend about the matter.
Lordship.
Who is the friend?
Friend, my lord, the petitioner.
Oh, you are the friend.
Lordship.
Yes.
Your Lordship, first of all, his, my lord, petitioner FIR was not at all registered, my lord. Your Lordship may kindly come to page 21. The amount he has paid to Asiruddin Ali, my lord, that is on 1st of January, my lord, 2026. Thereafter,
This
my
was
lord,
in earlier occasion, my lord.
earlier occasion,
His
what-
vehicle was taken on rent time to time.
I do
So
not know what, for whatever
It- it-
reason maybe, but on that day particular, now he is, my lord, trying to, my lord, shift all these allegations to Asiruddin, but there is, my lord, continuous, there is relationship of Asiruddin with the present petitioner, my lord. And those amounts which he has annexed, my lord, were paid in the month of, my lord,
page 18
from
is
January
recent
to,
receipt. Page 18.
March, my lord.
Page 18 in the recent receipt, my lord.
So only, my lord, schedule will reveal how he is, my lord,
He has
vehicle not
already
yet
appeared.
recovered, my lord, theft of vehicle. So, my lord, at this stage, my lord, only CD may be called for, my lord.
Petition has already appeared
And
before the IO.
his FIR was also, in fact, not registered, my lord.
Part Mr. You are Ali or Ahmed?
And that
you are Mr.
DPS was
Lost.
also disconnected.
Ahmed, you are Mr.
R. Ali, my lord.
R. Ali. na?
Lost.
Part Mr. R. Ali did not petition. Part Mr. P. bought and petition. We bring on the application that section. Next, submitted by Mr. R. Is it however, it is effective being the owner of the agency. He took the vehicle of the informant on it, and from him, another person took the vehicle on it. But thereafter, the GPS tracker was disconnected, for which he also informed the police concerned station. He also received notice from the station, and accordingly he cooperated in investigation, and his statement is also recorded. Right? But as case has already been filed by the former, he has the apprehension and in connection with this case, and for which the present FI has been, and which present petition has been instituted, praying for anticipatory appeal. Next paragraph, Mr. Porter put an additional submitted in its reply that there is no recent transaction of money received, which has been submitted by the petitioner, and he submitted that the CD may be called to know the accurate facts. During the submission made by an other aspects is vis-a-vis the cooperation already extended by the petition. This court is of opinion that interim protection may be provided with the present petition till receipt of the case. Okay, you will be under interim protection.
I'm all right.
On my lord, 29th of May,
20.
29th of March.
20. Twenty-nine. Yes, 5.
Right, fellows. But the petitioner is not named in the FIR. Education is that might have some better is why might have stolen from one of the company. And ultimately all of them are seized from the other person. The petitioner got a notice under page 35. That's why he is pending against my kindly see page 11 in the affair.
Yes, Shahid Ali.
We'll just tell page 19.
So batteries which are already stolen were
Education is, but in fact, my paragraph 4 I have stated the one person, Madam Mukhtar name, who was arrested already. He came to my because I am having GST, I am having license also, my electric shop, my lord.
You are not the company person. You are
No, I am not the company. I am having a shop, my own. So he came with 2 batteries, my lord, saying that it is already useless. So you keep it in your house. It may use for that year. That's why, my lord, I kept it. Subsequent on the same night, I came from the social media. The 10 batteries were stolen from the company. Then immediately I called that person. And I came to that maybe this include in the 10 batteries, so you take it back. It was taken back also. And all the 10 batteries were recovered from the possession of the person who had been arrested. Paragraph 9 by the page 9 to onward, all the 10 batteries were recovered from the different persons. Page 19 onward, my lord. All the season list I have given. So I am now only apprehending, I will appear, my lord. I will appear only, my lord, I need some protection, my lord. That is nothing. I am not, nothing is there, my lord. Nothing is required from my position. Nothing is there. Page 19.
My lord, 10 numbers of lithium
Yes.
battery from the my lord, other accused person from whom those my lord were recovered. My lord, only CD will reveal, my lord, whether all those my lord lithium batteries were actually those are my lord the lithium batteries which were my lord kept as mentioned in the FIR. And regarding the involvement of the present accused persons, only case diary will reveal. Otherwise, those are my lord highly valuable items of the
Yes, that already
tower.
recovered.
Mobile tower. And allegation is that on that night, my lord, by breaking my lord shelter room, those accused persons, my lord, committed theft.
Those are already taken to custody, my lord. Page 19 onwards, all batteries are
Any
recovered.
sorted-
Same batteries, my lord.
The CD.
administrator and its senior
A. Mohammed.
AM. AM and constitution. People it's the being on behalf of it's an application section
Unkana.
next one is submitted by Mr. Choudhury, senior president. Accused petitioner is no way connected in the list. However, it is the fact that he runs a electric shop wherein one person came with 2 batteries which he received accordingly, but subsequent when it has come to his knowledge that 10 numbers of batteries are being stolen from a company, he immediately called the person and returned the batteries. Only the 10 numbers of batteries have already been recovered from the possession of the witness. However, the present petitioner received a notice under section 553 from police station, and for which he filed the present interceptory bill application as there is apprehension of arrest. However, he is ready and willing to extend his cooperation in the investigation of this case if he is provided with some information. Mr. Botwood, the learned submitted that only city will reveal the involvement of the present petitioner, and accordingly, he insisted to call for the case. Next, hearing this submission by learned counsel, considering this court is of that interim protection may be provided to the present petitioner till receipt of this. Okay, you'll be under interim protection.
Obliged.
Yes,
On 26 payment.
What is the say? After 30 any day.
গোটে দিন 20 তারিখ
না থাকতে
Either
2nd of April.
2nd of
2nd of April.
June.
Oh, June, yes.
June.
2nd of
Obliged.
Yes,
May I
sir.
please, your lordship. Lordship entered 482 application, lordship. In this case, lordship, the FIR will find page number 10, lordship. And 2 number of gods, lordship, has been recovered from the vehicle, lordship. But apparently, lordship, as per the FIR, lordship, and 1 person is run away, and the 2 got already been recovered and handed over to the owner of the god, lordship. And subsequently, lordship, 1 notice has been issued to me, lordship, that because this vehicle is driver by one Sohaib Ali, he has already been arrested. Subsequently, this vehicle is belonging to my mother, lordship. Well, 1 notice has been issued, lordship. And but otherwise, lordship, apparently FIR is there is nothing has been further investigation is more, lordship. Kindly may I read, lordship, page number 10. Page number 10, lordship. FIR. Type okay. And with due respect, the owner would like to state you that I, Sri John Kolita, so and so, Bortespur, and so, was to lodge an Azahar against the god theft on so, and at around 12:45 p.m. On the said day, 2 unknown people forcefully picked up god from National Highway for Bortespur in swift car so, and 1 thief was caught by the public in Rampur with 2 gods inside the car, and 1 ran away from the place, and 1 black god and that is Khashi was found inside the car, who is market value 10,000, and another white female goat was of Gita Kolita so, and who is market value is 8,000, lordship. So, well, and already been recovered, lordship, and the person is in custody. But I am ready to cooperate, lordship, that because vehicle is belonging to my mother, lordship. But I was not there, lordship. Already been recovered and handed over to the owner of the court, lordship. My humble prayer, lordship, I may be protected, and 1 notice has been issued to me, lordship. Kindly come to page number 18.
গরু চুর করে লৈ যায়, ছাগলী চুৰ কৰি যায়। বেছি আজি সোমোৱাই দিয়ে না। Yes, what?
Yes, let him appear.
Items of the learned counsel petition. Mr. P. Porter. The learned additional BP appearing on the application. It's an application, section 12, it's submitted by Mr. Cobb that the learned counsel petition that it is not connected in the alleged documents. However, it is the fact that the vehicle belonged to his mother, who is the registered owner, which has already been seized by police with the allegation of committing theft of 2 boats. However, 2 boats have already been recovered and the driver of the vehicle is also in custody. He filed the present petition as he received notice under section 35(3) BNSS, and he is ready and willing to appear before the High Court as there is an apprehension of arrest. He needs some interpretation. Mr. Water, he learned additional people, raised objection, and submitted that and insisted to call for next hearing is sufficient. Considering all occurrences, this court is of opinion that interim protection may be still received. Okay, Mr. Howe, you'll be under interim protection.
Lordship.
On 28th February.
Deeply obliged, Lordship. Deeply obliged. Obliged.
In this matter, LCR was being called for. He is behind the bar since 175 days.
LCR is similar.
This matter is a certified matter, Your Lordship, where the charges were also being framed and the last 4 dates were fixed for evidences, but no PWs has turned up in this case. And Lordship is behind the bar since 175 days as of today. Since the matter is in evidence stage, Your Lordship, there is no chance of tampering of the evidence, Your Lordship. So,
what is the nature of this?
Your Lordship, 103 is there, Lordship. 103 is there, but in order to defend his case, Your Lordship, he will be allowed to go on bail so that he can defend his case with his own lawyer. Lordship. He's not being able to stop by his own lawyer.
Okay. My lord, here I am gone to the record, my lord. Here, my lord, 1031 subsection 1 is in his against him, my lord. He has brutally assaulted and in criminal manner killed his wife, my lord.
Why?
Wife, my lord, with a long knife, my lord. And search frame only on, my lord, 10th March 2026, my lord. And Lordship, kindly see the PM report, my lord. How brutally he killed his wife, my lord.
In which
And
case,
penetrative,
here,
my lord. Penetrative injuries were also there, my lord. And one sub injury. Sub injury. And important thing is that, my lord, there are several eyewitnesses, my lord, in this case, my lord. And evidence is not yet started, my lord. Evidence started, but PW is not turned up, my lord. Here, Lordship, it is not the case at this stage, my lord.
Well, Lordship, that will be proved during the trial, Your Lordship, whether the allegation is true or false, whether he has committed the crime or not. He is behind the bars in 175 days, considering his age, Your Lordship, is 25 years. And that allegation that has been made in the FIR is also not so correct, Your Lordship. There was a tussle between the two parties. That was his first wife. He was also being injured, but he has not committed any crime or like he has just penetration and something of the knife is allegation that has been given therein. That will become during the trial.
That's why I am praying for the malad. Some eyewitnesses are there, malad. Let them examine malad. Thereafter, court may consider their prayer.
Now, Lordship, in order to defend his case, also he needed a lawyer of his choice, Your Lordship. I pray before Your Lordship to consider the prayer of bail, Your Lordship, in this case, so that considering the length of detention.
His child also examined malad. 161 statement was accepted. 9 years old child, malad. Several material witnesses are there.
If it had been of the 70, 80 days, Lordship, I would have not faced, but now it is 175 days, Your Lordship, and 4 occasions PWC has not turned up, Your Lordship. He will face the trial, any stringent condition may be given, Your Lordship.
Day before yesterday, also Lordship, your Supreme Court has observed that the right to speedy trial is violated. Bail must be granted regardless of the crime seriousness. Lordship. And in this case, also PWS has not turned out. Any stringent condition may be.
You're Mr. S. Ahmed. Heard Mr. S. Ahmed, the learned counsel for the also heard Mr. Sharma, the learned counsel will be appealing to the This is an application of section students connected with students. Scan copy of PTC along with case study. Next slide, submitted by Mr. Ahmed that the present accused petitioner is diligent and has not committed any such offense that is in the FI. The petitioner is in custody since last 175 days and till date the prosecution could not examine any witnesses to that in 4 consecutive dates the PWs did not turn up. And the door as the on 4 consecutive dates the PW did not turn for reducing evidence. He further submitted that the accused as the accused petitioner is behind the bar, he could not take his proper defense, which is essential for it. Could not take his proper defense and could not discuss about the matter with his engaged counsel. Further submitted that considering his strong interpretation as well as the long the pendency of the trial pendency of the case, he may be released on bail, which otherwise violates the Article 21 of the Constitution of India. However, he is being a local resident, will appear regularly before the court and will extend his cooperation in further investigation. No, in further, sorry, will appear regularly before the court as and when the date is fixed by. Next, Mr. Rama, the learned additional PP submitted in his that the cases of under 103 BNS, and it is there is an allegation of committing murder of his wife, who was brutally killed by the present petition. He further submitted that the charge is framed only on 10/3/2026. Very short dates have been given by the execution, though till date the witness did not turn. Mr. Sharma further submitted that there are eyewitnesses, including a child who also is the eyewitness. Statement has already been recorded by the eye. Accordingly, he submitted that till the recording evidence of eyewitnesses, the prayer for bail may not be considered, as there may be chance of tampering with the evidences of the witnesses. Mr. Sharma accordingly raised objection and submitted that may not be a fit case to extend the privilege of bail to the petitioner at this stage. Next, hearing the submission made by the counsel, I have also filled the DCR, scan copy of the DCR along with the case diary. It is the fact that till date the prosecution could not examine any cases, though summonses were sent in within a very short. It is further seen that the charge has been framed on 10/3/2026. Thereafter, case is fixed for evidence. Next date of evidence is fixed on 45/2026. Next paragraph, further from the result of the record, case diary, it is seen that the 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 deceased was brutally assaulted with a sharp object. There are several penetrative injuries, including one chop injuries on her face, which seems that the victim was very brutally assaulted and killed. Assaulted and killed. It is also seen that there are eyewitnesses, including a child, and hence probability of hampering or tampering with the witnesses, especially the eyewitnesses, including the child, cannot be rejected, outrightly rejected at this stage. Next paragraph, considering the nature of as well as the other these aspects of the case, this court is of the opinion that bail, the present petitioner is not entitled for bail at this stage, according to the petition stands. Your petition stands.
Madam. All right, sir.
Madam, item 47, your lordship called initially. I was.
It's
Yeah,
already ordered, order is already passed in 47.
Your lordship, I was
So
under
you
the
have, that's why we considered and we fixed one date, I think. I don't. It
My
is
lord.
not, yes, 47, no? 47, we fixed it on 13/5. 1/3, 13.
13/5.
Sorry.
Go ahead.
Because it was a BA, that's why we.
City's code. City call again. But a BA, I'm sorry to intervene, my lord. The BA, a consenting party, both lady just with a promise to marry, my lord, that is the allegation, my lord.
69, I think.
Yes, yes.
Then আপনি লসিল লিঙ্ক একটু নান অ্যাপিয়ার্স টু লিখিছেন সিটি কল করো ওকে করবি কল করছে
Obliged.
17.
In item 70, charge sheet submitted.
Lordship, since the investigations complete, Lordship, no further custodial.
No, charge sheet submitted. You have to appear before the land.
My lord.
Your good name?
P. Das, Lordship.
MS?
P. Das, Lordship.
P. Das. Hard MS P. Das. Also hard distribution. Is submitted by Mr. Sharma. That case has already been charged. Yes.
I charge sheet number 46 of 26, dated 30/13/4/26.
The petition is in custody since when?
30 days, Lordship.
30 days. However, it is submitted by MS Das that the petitioner is in custody since last 30 days. And hence, considering his length of detention, a prayer for bail may be considered. But as the case has already been charged, the petitioner is hereby directed to appear before the learned and court below with an appropriate application for bail, which may be considered in accordance with the above observation. Okay, I have recorded your submission that he is in behind the bar for 30 days. That may help you. What is 20?
CD is perhaps not received.
CD not received.
Item 20, CD not the same. They are interim, no?
Yes, sir.
CD not received. Issue reminder. Yes, when it can be.
From Thuguri, my lord. 21st, my lord.
21st of May. when
My lord.
Your interim be extended till next day.
Obliged.
Senate CD. May I
We have
please, your
received-
lordship?
Just a second. We have received this scan copy. I think.
Scan copy, yes.
Lordship,
Yes. Yes, submit. Yes.
almost 70 years old man.
Hmm.
He is accused of section 376 earlier.
Yes.
Right.
What to do?
Now, lordship, I am on interim. Lordship. I appeared statements recorded, my lord. Now the problem is that this is a sessions tribal case and case is not committed. CD assembly.
I have trademarked the statement of the victim and one eyewitness heard, my daughter's statement is also there, my lord. Daughter also, my lord, supported the case of the victim.
So my humble prayer is that as I was in interim, I am cooperating with the investigation, lordship, till the commission of the case before the proper trial court, lordship. I may be protected, lordship. Otherwise, because in this court where it is presently pending, if I appear, I may be arrested, lordship.
Is he shown as the respondent or no?
My lord, that I will have to check again regarding his statement. So within this statement.
Absconder is okay, but whether his statement is available.
Yes,
As per him, he appeared and
statement, my lord, I have.
It will be in the CD, most probably.
yes, sir, we have received the CD.
So it's.
Just I want to say one thing, that this his interim was granted on 20/01/2026. That is 28th of March, January.
Yes.
So Charge was submitted.
Submitted on 6/1/26.
Oh,
6/1/26.
then too it will be problematic because
Yes.
you have not appeared.
Yes.
Prior to your appearance, charge has already been.
Prior to the interim order.
Yes.
Prior to the interim order.
Yes.
Maybe, lordship, maybe, it may be. I don't.
CS submitted on 6/1/26. Interim granted on, my lord, thereafter on 21/26. For his.
Lordship, my prayer is very much simple, lordship. My interim may be considered up to only till the commission of the case before the proper trial court.
Because obviously he was an interim, but
Yes.
he
It's already in.
prior to his appearance, most probably the charge sheet is already there. Is somebody can. The should be important. Should be we are to respond. This is an application for section students. Scan copy of the picture with its Right, submitted by Mr. Soma that during the pendency of the present petition, the IO filed with charge sheet against charge sheet in the present case. However, for obtaining the order of interim payment, he appeared before the IO and extended his cooperation. If further submitted as the case is of section strap, he may be allowed to remain on his previous bail, interim bail, till the case is committed before the learned decision. Next, Mr. Waterford learned submitted in this that the record that that the that the statement by the victim as well as her daughter implicates the present petition, and at the same time the case is shown as an absconder in the charge sheet. However, it is submitted by Mr. Bott that the petitioner got his entry on 20/01 and the charge sheet was filed on 7/01/6. That is prior to the order of interim periods. Next one, considering the section with that and the is the admitted fact the charge sheet was filed prior to the order of interim periods to pay, and for which the accused was shown as a considering thus the statement of the present petition is also accurate indicates that it is submitted by Mr. Soma that petitioner appeared to be I reading of 3 years. Considering all these the petitioner is hereby directed to appear before the learned trial court below with an appropriate application for regular bail. However, till the court the case is committed for the learned session judge, the interim granted earlier petition will remain in further the committal court of its trial court is hereby to make all necessary endeavors to send case record for the learned session judge within a reasonable period. With the above observation present, your interim will be extended till the case record is
Deeply obliged, my lord, deeply obliged.
May I please, your lordship, that this matter may be kindly adjourned for the day, my lord. Engaged counsel is not come, my lord, due to some personal inconvenience. my lord.
This case is otherwise.
yes
For one day, my lord.
that's it. We have received the case diary.
Case diary received. Then, my lord, in this case, my lord, there are lots of allegations against the accused person. Only statement of the victim complainant is there, my lord, regarding medical report, everything that, my lord, injury report, long, all these things are only statement of the, my lord, victim complainant, and the, my lord, statement accused person appeared, his statement also there. My lord. Otherwise, new IO has taken over the charge. Thereafter, my lord, no investigation in the case. So I will have to up to date. He is already under interim. I will have to send back for update.
You are Mr. Rahman or
Al J. Ali, my lord.
J. Ali.
May I appearing on behalf of Mr. S. Rahman, my lord.
Part Mr. J. Ali appearing on behalf of Mr. S. Rahman, the learned counsel for the petition. Also part Mr. B. Board for the learned PP. It is submitted by Mr. Bott that is CD received, but it is not updated, and there is no other investigation after the taking over charge by the new investigator. Mr. Bott accordingly submitted that the CD may be returned. Call for a in view of this, let the CD be returned, asking the new investigating officer to make proper investigation of this case and collect the injury report and other statements of the witnesses and to submit the updated case diary on or before the next day when it can
On 4th of June, ma'am.
let the matter be accordingly listed in be continued listed.
In time continue, madam.
Yes.
I'm obliged.
Ma'am, please, your lordship.
Yes, you have received your his objection.
Yes,
Yes, objection you have filed. I have. You have received.
Objection. In the meantime, your lordship, they have already filed another additional affidavit, your lordship, whereby some photographs they have brought in on record, your lordship. The affair is at page 14 of my additional affidavit, kindly have. In the page 14, your lordship, have got it. In my additional affidavit, your lordship.
Look out. Look out. Yes, 14. What do you want to show?
Yes. Page 14 of my additional affidavit. This is the affair, your lordship.
You lost.
Yes. And the petitioner, they are, your lordship, from one family, they are the brothers, and one is the father of the rest of the petitioners here. I'm reading what is in the affair, your lordship, they have stated. It is respectfully stated that 1/5/2026 at about 3 p.m. I was conjointly attacked by the above named accused person with lathi, zong, sharp weapon while I was throwing chemical fertilizer on the land of my father situated at village Bangugi. Thereafter, I was caught hold by A. Rashid and Asraful. My left ear was taken away by Sofikul Islam, biting with his teeth. Resultantly, I have sustained grievous injuries. Later on, I met hue and cry, and people came forward from all corners, and thereafter I was rescued. Since the dispute was arose in between one, and it was also issued by the elderly person to settle it amicably, and moreover, I was busy with my treatment for which there is delay in lodging the affair. In the affair, they have stated that the Ellis incident was taken place on 5/1/2026 and the affair was 5/3/2026. Almost after 2 months, your lordship, this affair was lost. And thereafter, in this case, your lordship, the petitioner, they were released on interim and we have cooperated with the investigation. I have to just leave everything.
So what
The
is the, where is the
objection-
present FIR against you? Where is the present FIR against you?
Just 14, your lordship, that I have already read out, your lordship.
This is the FIR lodged against you,
Yes,
or you lost the FIR?
no, we also lost the affair, but that affair was not
Not
registered
registered.
by them.
No, this
By
is
the
the
police,
FIR
yeah.
lost by them.
That means, your lordship, by the police. Our affair was not lost by the police. It was not registered by the police.
I can understand this 14 FIR is lodged by the other side
Yes.
against you.
Against this, your lordship, we are before your lordship.
Acha. So how many? 5 years there?
Yes. And 5, but the petition. I said 5 petition. And out of this 5 accused, your lordship, except the accused number 5, your lordship. What is the petition? Except the, I am not appearing only for the accused number 5, your lordship. This affair is against the 5 accused person, your lordship, but I am appearing on behalf of accused number 1 to 4, your lordship. And the informant, he is the cousin of the present petitioner, Your Lordship. In fact, Your Lordship, on 5/1/2026, there was some altercation. That means the informant and their family members illegally entered into the land of the petitioners, and thereafter they assaulted the petitioner, Your Lordship. But in the written objection, Your Lordship, they have annexed some photographs, Your Lordship. I have also seen it, Your Lordship. Page 28, Your Lordship, kindly have a look at it. Page 28. Page 28 of their objection. Regarding these photographs, Your Lordship, the petitioner, they have denied. And there was no such incident, Your Lordship.
20,
9.
41. Wait to 20. Calling an effect. Go to it. You put it. What you did all the continue. Yeah. 20, that means they file earlier one.
Yes,
objection.
yes. In 28, it is the objection file. In 28 is the objection, and today
They file an additional.
in 28. Regarding this, Your Lordship, this photograph, Your Lordship, I have taken instruction from my client, Your Lordship, and they have denied it. They have denied it, Your Lordship. In last occasion, I have placed some copies of the plaint, Your Lordship, which is going on in between the parties, Your Lordship.
The civil
In
dispute
fact,
is going on, no issue.
In fact, Your Lordship, that day, Your Lordship, my friend, Your Lordship, made a submission that threatening, Your Lordship. But in fact, threatening, we have been receiving threatening from them, Your Lordship. And the cause of threatening is to compromise the civil suit only. So the photograph, whatever they have placed, Your Lordship, I have objection regarding this. These are not the photographs of on that particular day. There was no such incident, Your Lordship. And maybe, Your Lordship, this is the era of artificial intelligence era, Your Lordship. So these photograph on the basis of this, we cannot. And last day, my friend also relied the case diary, Your Lordship, wherein the injury report says that the injury sustained by the victim, Your Lordship, is simple. Now,
Against the
My lord, I have received. that
Auditor-
case. My lord, I would like to point out. what
After-
is-
No. Who will authenticate this photograph? Now the question is that this is not the subject matter. Now, Your Lordship, I am on the.
They have committed the crime. They are denying it. And there are other examples that they have, they have received video and they have also then go photograph. Whether they have hide or not, that is known to you. And if they have typically some medical matter, ask you to I think that is after that,
Mr. Bhattakar, have you seen
Um,
photographs?
Yes, photograph I have seen, but those photographs are not part of the case diary, my lord. From the case diary, I would like to point out, my lord, from the statement of the eyewitnesses and type of injury, I will explain to your lordship, my lord. Well, eyewitnesses stated that, my lord, well, yes, there is regarding that, my lord, injury of the arm, my lord, there is specific materials is there, my lord. I am just pointing out vital. আমাৰ লগত খাদিজা আৰু ৰুকিয়া দুয়ো কাজিয়া কৰে আৰু আশ্ৰাফুল আব্দুৰ ৰচিদ আশ্ৰাফুল আৰু আব্দুৰ ৰচিদ দুয়ো মোৰ ভাইটি আছাদুল ইছলামক আগফালৰ পৰা ধৰে দিছ ইজ ইম্পৰ্টেণ্ট মানে আৰু পাছফালৰ পৰা ছফিকুল ইছলাম ওৱান অফ দি পেটিচনাৰ নম্বৰ 3 মানে ছফিকুল ইছলাম আহি বাওঁ কাণত কামুৰি দিয়ে আৰু কাণৰ এটা অংশ ছিঙি পেলাই আৰু গুৰুতৰ জখম কৰে and regarding that this is one eyewitness there are two other eyewitnesses same my lord statement and regarding and my lord from the injury report my lord injury report my lord yes although injury is simple but my lord I would like bite mark over left arm size 4 into 2.5 into 1 cm left arm my lord simple injury and again my lord, ENT consultation for needful surgery consultation for needful these are the although simple injury but yes from
Surgery
eyewitnesses also supported regarding bite mark in the arm. Again, Sofikul Maluk, petitioner number 3, specific allegation that he is the person Maluk who Maluk bite the arm of the Maluk. Other persons were also there, mainly specific against Sofikul.
Since there is interim, your lordship, we have cooperated with the investigation. Your so
Mr. A.M. And you Mr. Talukdar?
Yes, sir.
And Mr. Talukdar did done it. Application went city receipt the Mr. Talukdar did done it also for the informant also filed his additional affidavit or of objection to initiative one filed by next submitted Mr. Khan done it that there was a family dispute, land dispute between the parties, and one civil suit is still pending before the civil court of against between the parties. The incident occurred only as when the informant side had pressurized the petitioners to withdraw the civil suit which is pending before the court, and in that context there was quarrel and scuffle took place between the parties, but no such incident had happened as allegedly happened. From the petitioner side also identified before the consultation but that has not been registered by police, and they were searched on behalf on the FIR filed by the others. However, all the petitioners have already appeared before the IO after obtaining the order of interim pre-estimate, cooperated in investigation, and are still ready to extend their participation. Mr. Bhattakar all the petition were investigated after your state they have appeared and their statements are Mr. Bhattakar further stated that from the injury report, seen that the injuries sustained by the victims are simple in nature, but but one of the victims was advised for consultation with the ENT surgeon as he received bite injury on his left. He further submitted that there are some eyewitnesses who also categorically stated that accused petitioner, namely one Safikul, had bite the left ear, bite on the left ear of, was the name of the victim?
Petitioner number 3, my lord. So
No, victim name Asra,
Ashadul Islam.
Asadul Islam.
Asad,
Some of the witnesses have also stated that one part of the ear was also detached due to the bite on the left ear of victim. Mr. Talukder, did I need
my lord, sorry, my lord, photograph is there, my lord. Photograph.
Tell Mr. Potpur submitted that photographs of the injury with test ear is also collected by the eye during investigation.
No, my lord, photograph is not of the part of the CD, my lord. In their
Oh, that-
petition, my lord. Not part of the CD. In their petition, my lord, I just, my lord,
In their petition mean?
in the petition filed by the petitioner, my lord.
No, not petitioner.
Objection.
Informative.
That's it. That's it.
Those photographs are not part of the CD.
Oh, then we'll delete that. Mr. Talukder did done it. Here submitted the petitioner had assaulted all the victims. Victims for a quarrel between the parties land dispute. However, no such injury is sustained by the informant side, for which not even FIR is lodged by the petitioner. He also submitted some of the photographs with injury on the ear, where from it is also seen that injury of the ear of the victim, wherein it is shown that he sustained severe injury on the ear, and one part is also detached from the left ear of the victim. Mr. Talukder accordingly submitted that all the victims were brutally assaulted by the petitioners, and accordingly raised women objection and submitted that custodial interrogation will be required to know the facts of the case, and he submitted that petition for anticipatory bail may be received.
Thank you.
Oh, but then why you are saying that you are pressurizing for
No,
withdrawal
no.
the same?
They have filed the civil suit. Your
Ah, now you are saying that they pressurized to withdraw the.
No, they have pressurized to compromise the matter, your lordship. This court. Not withdraw
Once you
your
are
lordship.
saying that withdraw, now you are saying compromise. Why they will
All the cases have filed by them, your lordship. We have
why
not.
they will compromise now? They are the
Now they are claiming that the land dispute is there, your lordship.
So why they will pressurize you to compromise the case now?
Because the land belongs to the petition number 1, your lordship. We are enjoying possession of the land, your lordship.
Whatever they have filed it, yes, they claim the right title interest.
They have made, your
Or
lordship, vexatious claim, your lordship.
position is also there. Why they will insist or why they will pressurize you?
Because they know it very well that they have made a vexatious petition, your lordship.
Let the
Therefore, only they
ends
approach us to compromise, your lordship. Otherwise,
make such submission, misleading submission. Once you are submitting and withdrawing, now you are saying compromising. Why?
And otherwise,
Why? What will be there on the part? They have instituted this civil suit because of illegal disposition by you. Illegal disposition by you, they have instituted this civil suit.
yes,
Claiming right at the interest and recovery of position.
Because
so why they will insist you to compromise the case?
they have filed
benefit
civil
they
suit
will
claiming
get now?
right title, interest, and recovery of possession. It
Yes.
means the land is Land, we are possessing the land, your
Yes,
lordship.
you are illegally
Yes,
possessing.
they approach us to settle the matter. That means to
Why?
get the
Why
land.
they will approach you?
Then why he has not filed any FIR, my lord, against the present?
No, no,
Yes,
they
why
have,
they will approach you?
they are, that is settlement, your lordship. I am saying the settlement, your lordship. They want settlement, they want get land, your lordship.
Now,
Okay.
for the, my lord,
Draw for the compromise. Research for compromise. Not fight. Purpose ওটা না আপনি না লাগে again. Like Mr. Tarver participated that this is also filed by the informant side claiming right to interest and recovery of commission over the suit property. Hence, question of preserving them for withdrawal seat does not add creating this from the photographs annexed along with the as the it reveals that there is a severe injury in the ear and one part of the left ear is also detached from the test, which is also supported by the ocular evidence of the eyewitnesses we who saw the incident. Eyewitnesses are supported by the eyewitnesses. However, it is the medical report is stated to be simple injury, though one part of the ear is alleged to have been detached from the detached due to bite injury by one people, the present accused petitioner.
Three,
petition number
Yes,
3.
petition number 3.
So, people.
Beating here, that allegation is against petition number 3 here. Beating like that.
You know, I just okay, so we could start. There are the implications against the other accused petitioners also who alleged to have been involved in the said offense. Considering the entire facts and circumstances materials in the case that not considering the objection filed by the informant, the order of interim disposal of obtained the custodial interrogation of the accused petitioner number 3, namely people, may be required for the purpose of investigating, and hence the order of prayer for pre-arrest bail for the present accused petitioner is rejected, and the order of interim pre-arrest bail granted to the accused petitioner, namely so and so, is hereby stands back. Next. the materials in the case diary against the other accused petition. The prayer for interim pre-arrest bail. Granted, no prayer, no, the order of interim pre-arrest bail. Granted to the present, granted to the other petitioner number 1, 2, and 4, 2 and 4 is hereby made absolute, and order of pre-arrest bail granted to the petitioner dated 73/2026 is hereby made absolute. Your Sophicol is rejected.
Yes.
Earlier interim bill stands back. Interim be continued. Next requesting. Yes, when it can be.
On my lord, 2nd of
Interim order may be
Yeah, we extending.
obliged.
25 CD.
May please, Lordship. 482 application, my lord. In these cases, Your Honor, Lordship, the allegation is that the physical and mentally tortured by the petitioners, and subsequently, before I going to the FIR, the petitioner number 1 is the husband, 2 is the mother-in-law, and 3 is the brother-in-law. And petitioner number 2, he is a old age, 57, is the assistant teacher of the school, and after 3 years, he is going to be retired. Now come to page number 20. Look. Page number 20 is the FIR. An allegation is that the informant substance they are physically and mentally tortured and demanded the dowry. And in subsequently, the police has registered case under 85, 62, 64, and 115 of the BNS.
$64.
64 cruelty, 498 on corresponding in IPC 498 and BNS 85 BNS.
85 is cruelty, 64, my lord.
64 BNS is punishment for attempting commit offense, punishable with imprisonment for life.
64 with 62, my lord. 62 is attempt to commit rape.
Attempt to commit.
Attempt to commit rape.
Yes. And 115.
And what is 64?
64 is the, my lord, rape, my lord.
Oh, that's what I'm asking.
Yes. But my lord, here allegation is, my lord, 62 is attempt to commit rape, my lord. From the, initially one complaint filed, thereafter, my lord, the same.
Okay, then that in otherwise we like 511.
Yes.
64.
64 BNS.
With 16. Earlier 511.
Yes.
And most important thing is that in her FIR, kindly page number 21, in the last 7 lines from the last column, she stated that she already left the petitioner's house. And main is thing is that she is separated in the year of 2022. There are no any question of physical assault or any kind of rape, because she already separated in the month of 2022. And why not kindly see in my petition para number 8. Para number 8, the petitioner stated that 2 cases was filed before the Borpata Principal Judge Family Court. One is divorce, another is maintenance, FC 671/25, and another is 436/25, which is pending and regularly they appear. Subsequently, both the cases are filed in the year of 2025, and continuously they are repeatedly filed FIR against that petitioner. Because kindly see the petitioner number 2, she is a lady as 57 years, which I am enclosed in my para number 13 in page number 9. 57-old lady, and he is a diabetic patient since 2020, and she is an assistant teacher of school. Now after 3 years, she is going to be retired. So how can it possible a 57 years lady is committed such kind of crime? And I am annexed in
It's possible. If it is 80 years can assault. Oh, no issue. 57, what is the
Annex number 324, I am annexed the medical report also.
working lady, no?
Yes.
Rather, she will put more torture on
Yes.
the
So in this case, Your Honor, 24 page number, I am annexed the medical report, page number 24, and more the kindly come to the I am annexed everything. What is the fact of the cases in page para number? Yes, para number 9, page number 7. neither the petitioner has committed any offense, never tried to harass the physically or mentally or demand the dowry, because they are believing in a joint family. And subsequently, the petition number 1, the husband is no more income physically is not sound, and the wife of the informant is demanded some money, and that's why he is separated, and they are believing the informant believing to separate the from her house, and that's why she is leaving her husband house in the year 2022.
Where from you're saying that she is living separately from 2022?
Yes.
Where from you're saying?
Sorry.
Where from you're saying that she is living separately since 22?
Yes, kindly see in the para number in FIR, she already stated that. স্বামী গৃহৰ পৰা মোক খেদি পঠিয়াই দিয়ে আৰু কয় যে এইবাৰ সুদাহাতে ঘূৰি আহিলে ফৰিয়াদীক হত্যা কৰাৰ ভাবুকি দিয়ে। ফৰিয়াদীয়ে উপায় নাপায় কোনোমতে প্ৰাণ ৰক্ষা কৰি ফৰিয়াদী ল'ৰা সন্তান হওক ফৰিয়াদী পিতৃ ঘৰলৈ ঘূৰি আহে। বৰ্তমান ফৰিয়াদীয়ে সন্তান হওক পিতৃ ঘৰতে আশ্ৰয় লৈ আছে। This is her statement in the FIR. Original fact is that she is separate in the year of 2022. Now is 2026. And two already cases pending before the Borpata police, which is filed by them 2025. One is divorce, another is interim maintenance case.
Where from you're saying since 22 she is separated?
As,
Where from you're saying this since 22 she is
yes,
staying separately?
as per instruction, my claim.
Oh, yes,
Yes, sir,
yes,
yes.
as per instruction only. As per instructions only you are saying. In the FIR there is no such
Yes,
statement.
yes. FIR,
FRD statement on
22 repeatedly you are saying. That's why I'm just searching for. Where is the 22?
yes,
Just
sir.
look here.
In FIR says she's left the husband house.
Yes,
In
it is
FIR says she
22,
left the
the
husband.
incident only.
yes.
Where from you are saying 22? No, try to miss it, and it is your submission only, not from the
Yes,
statement made in the FIR.
and kindly
From
see,
what
there
you
is no any medical report was submitted by the
yes, what?
informant.
Yes, my lord, CD received, my lord. In her statement, she stated that all these accused persons, my lord, mentally and physically tortured. Thereafter, my lord, initially they demanded, in her statement, the father of the, my lord, initially demanded an amount of rupees to the father of the company, 1 lakh. Thereafter, my lord, again, he paid that amount. One thereafter, again, my lord, demanded an amount of rupees 2 lakh. And thereafter, my lord, while they again demanded an amount of rupees 3 lakh. Those are the statement of the complainant, my lord, along with a Maruti vehicle.
My lord, these statements.
Just a second.
These are the allegations of the, these are the statement of the complaint 161 statement. The thereafter complainant also alleged that the petitioner number 3 here in Manjurul Haq, my lord, he attempted to commit rape while her many times, my lord, and while she reported to the petitioner number 2, my lord, mother of the, my lord, her husband, then and her husband also she reported, then they did not take any action, my lord. In fact, my lord, thereafter they also in fact assaulted. These are the allegations, my lord. And thereafter on 4/11/25, my lord, all the 3 accused person allegedly assaulted her physically and forcibly drove out from the matrimonial home. So from 4/11/25, she, my lord, drove out from the residence of the. These are the statement of the complainant, my lord. And regarding some of the witnesses stated that they only, my lord, 1 or 2 witnesses is there, my lord, investigation is going on. They only stated that they only heard about those, my lord, thing, but specifically no one stated regarding those, my lord, supporting those allegations of the complainant regarding that investigation is going on. And my lord, regarding that, my lord, assault 115(2), my lord, section, regarding that injury report not yet collected, injury report is not there in the CD, my lord. Otherwise, my lord, these are the allegations by the complainant, and now, my lord, as per note of the IO has asked the complainant to report him for recording 183 statement. My lord, till now he has not, she has not come to the police station for recording 183 statement.
So 183 is not.
183 statement is not there. And my lord, investigation is still going on regarding other allegations. Only till now 2-3 statements witnesses recorded, my lord.
My lord,
Mr. Arkena.
My lord.
And after obtaining
my lord,
intent, they
kindly see the page number for one moment, my lord. The learned friend stated that we are demanding money 1 lakh, 2 lakh, but specifically stated by the complainant in the year of 2020, 7th of 5, 2020, they are demanded money 1 lakh in the year 2020. Now we are to 2026, my lord.
But Mr. Arkena, the learned counsel, the petitioner also heard. Should be portable, the learned petitioner appearing on the It's an application under section so and so in connection with so and so city. is submitted by Mr. Nada, representing accused petitioner. The defaults and concocted allegations are being brought against the present accused petitioner by the victim after leaving her matrimonial house at her. He further submitted that the allegation of demand of dowry, etc., is also mentioned for the year 2020, and there is no other materials of demand. There is no other allegations of demand of dowry in her petition. He further submitted that the petitioner is staying separately since year 2022 after leaving her matrimonial house, and with some false allegations, the complaint has been instituted against the present. However, after obtaining the order of interim pre-arrest bail, all the petitioners have appeared before the IO. Their statement is recorded, and they have extended their cooperation. Next paragraph, Mr. Botapu, the learned petitioner, submitted in the debate that the victim in her statement made under section 180 of the BNSS has brought sufficient incriminating evidence against all the accused petitions. It is enlisted on 4/11/2025. All the accused petitioners have assaulted her badly and drove her out of the house. However, he submitted that the case is still under investigation and accept one of the two independent witnesses. Other witnesses are, the statement of the other witnesses are not yet recorded by the IO. Mr. Waterford further submitted that the informant was notified to appear before the police station to record her statement under section 183 PNSS, but till that she did not appear before the IO for recording. However, he submitted that all the accused petitioners have appeared before the IO and cooperated with the investigations. Hearing the submission made by Lanika and also with the case diary and considering the materials available in the case diary, cooperation extended by the petitions. This court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. In view of this, the order of interim pre-arrest bail dated 16/03/2026 is hereby made absolute with same terms. Okay, your petition get absolute. Yes, what is the question of 26?
Well,
They
in
were
this
not
case,
interim.
case diary not received, my lord, wrongly, my lord, the IO has sent, and here case number is, my lord, 4026 Dibrugarh. But they have intimated one intimation regarding a filing of such sheet. Case number is 40/25.
It for Dibrugarh only or?
Dibrugarh PS 4026.
No. Our present case is Dibrugarh 4026.
26.
And your
So report received regarding 40/2025. So my city notice.
the name, just name, see the name. Here it is common site here.
No, well, Kishore Kumar Thapa name is also different.
You are MS?
Lordship, B. Sharma.
Ah.
Lordship, Lordship may consider in protection.
No, in the investing on the initial date it was not considered, so may not be considered at this stage. Otherwise, also it will be case of 316 and 5. Let us see the case diary. Heard MS Sharma, the learned counsel for the petitioner, and also heard Mr. P. Botaku, the learned additional PP, appearing on status submitted by Mr. Botaku that a wrong report has been submitted by the IO in connection with Dibrugarh PS case number 40 of 2025. So the present case pertains to Dibrugarh PS case number 40/2026 under section 316/. In view of this, a learned additional PP is hereby directed to issue press requisition for the CD for the of the present case. Present case.
Next week, Lordship.
Issue next week, it may not reach, I don't know. Possibility is less.
14.
Possibility on the next week is less. Second, that's why we are giving you on 14th. Okay, because from Dibrugarh it has to come.
Yes, Lordship.
14th.
Deeply obliged.
27.
May please, your
Yes,
lordship.
what is the just a second? What is the position of 26/7?
Report was called.
This matter may kindly take after sometime like 2 months.
At 2. At 2 p.m.
Your Honor, the petitioner is already an interim and as per
You
my
have received the
instruction.
case diary.
Yeah.
Yes, you are on interim. Yes, then.
The affair in the page number 23, my lord. And it is a relationship, it is a broken relationship. After that, the informant has filed an affair. My lord. And there is nothing, my lord.
23.
23 page number. May I read the affair, my lord? সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই গোপাল নগৰ শিৱ মন্দিৰ পথ নং বাস কৰোঁ। আজিৰ পৰা 6 মাহ ধৰি মোৰ লগত শ্ৰী চিন্ময় নাথে পিতা গোপাল নাথ হাং আজাৰা তাঁতিপাৰা থানা আজাৰা মোক বিয়া কৰাম বুলি প্ৰতিশ্ৰুতি দি মোৰ পৰা প্ৰায় 3,03,030 টকালৈ ব্যৱসায় কৰাৰ উদ্দেশ্যে টকা লয়। প্ৰায় 4 মাহ ধৰি মোৰ লগত সকলো ধৰণৰ কথা বতৰা আৰু একেলগে ঘূৰা ফুৰা কৰিছিলোঁ। আমাৰ দুজনৰ মাজত ভালপোৱা সম্পৰ্ক চিন্ময় নাথৰ মাক দেউতাকে জানিছিলে। এতিয়ালৈকে ঠিকেই আছিলে। তেওঁ মোক মোৰ লগত শাৰীৰিক সম্পৰ্ক এটা গঢ়ি তুলিছিলে, কিন্তু এতিয়া তেওঁ মোক বিয়া নকৰাই বুলি কয় আৰু বিভিন্ন অজুহাত দেখুৱাই মোৰ পৰা আঁতৰি আছে। মই জানিব পাৰিছো যে তেওঁ বেলেগ ছোৱালীৰ লগত সম্পৰ্ক ৰাখিছে আৰু ইয়াৰ উপৰি বহুত ছোৱালীৰ লগত তাক মিছা প্ৰলোভন দি জীৱন নষ্ট কৰি আছে। মই এতিয়া মানসিকভাৱে ভাগি পৰি আছো, গতিকে মহোদয়ক চিন্ময় নাথৰ বিৰুদ্ধে বিহিত ব্যৱস্থাৰ বাবে প্ৰাৰ্থনা জনালো। Broken relationship and promise to marry, my lord.
So, for you, it is not an offense.
The CD will reveal, my lord.
Yes, what?
My lord, here the CD received, my lord, in 183 statement, he has categorically implicated the active person, my lord. And also allegation is that he has also taken 3 lakhs, 3.5 lakhs from her and also her family members. That allegation are
Taking money, my lord, this is a civil dispute, my lord.
As per him, she was elder to him 4 years.
Yeah.
As per his statement, she was 4 years elder to him. You are Mr.
R.D. Bhuya.
Pardon, Mr. R.D. Bhuya. Two R.D. Bhuyas are there.
Yes, one is my elder brother.
R.D. Sharma is an action agreement. Submitted by Mr. Bhuya that representing and it is both with after the relationship between him and the was not and the promise of marriage, false promise of marriage, or neither any money has been received by him. The further subject, even if the money is and no, at best it may be a case of civil, it may be a case of civil in nature, and a government very rich becomes. However, profiting the order of simply an estate, he appeared before the court and cooperated. Mr. Bhuya further submitted he is still ready and willing to act in his cooperation if he is granted with the privilege of it. He is stepping by the victim, whereas the other is sitting with his son. Submitted there are by the victim. The order of the Spain, dated 2603 is hereby made absolute.
Yeah, please.
Yes, what is the full city receipt? City receipt.
City receipt. The petitioners are already on interim bail.
You appeared before the IO?
Yes, appeared before, minor. Appeared before the IO and statement also recorded, my lord. Yeah, my lord, Lordship, can be 183, my lord. Yeah, the prime accused already granted bail by this honorable court, and
These are who are they?
yes, they are the guardian seems to be their role only to the marriage part.
Your petitioners are
My lord, Mirazul and Abdul Rahim. Mirazul and Abdul Rahim.
and the prime accused, as per you, prime accused is?
Yes, accused number one, FNM accused number one, he has been already granted bail.
He is?
Sohail Mahmood. Sohail Mahmood.
Sohail.
Yes, absolutely. It is on the associate pardon. And the main allegation against the accused number one was
Yes, Amit. city receipt is submitted by Mr. That's the version of the prime used one so built, and they are they are not at all related in the LS documents. However, after getting the order of the LS paid, they already appear before the eye, and their statements are also. They are still ready and willing to extend their operation if they are granted with the privilege of real estate. Next, they run it submitted. But there are some materials against present petition. However, they have already and extended their cooperation. Next, it is submission in 2702. Your interim bill dated 27/03/2026 is hereby made absent.
Here CD receipt.
CD receipt.
Ma'am.
Yes.
After interim appears statement also recorded, my lord. Your lordship in the similar. One 183 CS category implicated the accused. From the witnesses also revealed that he is also earlier also in several occasions he is different women might type of.
Medical is also there. Medical. अच्छा तौबा मारी थोड़ी no other allegation.
No. Sixty to 64. 70.
60?
62, 64, 75, 1.
He narrated a complete different story. He accused. He narrated a function.
That is different story. In his statement, man.
Yes, what is your submission?
Lordship, our senior is on the way, so we would request you for some time. After 2.
After?
2 p.m.
At 2 p.m. Okay.
Phone?
May I please, Lordship? It is a case of love affairs, Lordship, not.
Yes, of love affairs.
Willingly, the victim girl accompanied with me, Lordship.
Achha. Willingly, the victim girl accompanied you. And then what had happened? Where is the FIR?
FIR is page 9, Lordship.
Page 9.
Victim girl is 16 years, Lordship. Last occasion, Honorable Court has directed to instruct from IO, Lordship.
মানে
Instruct means
My lord,
regarding the service or what? Regarding the service.
it is already written
directly
in the honorable
instruct-
court, but the honorable court has instructed why only section 87 is incorporated, Lordship.
So what kind of instructions was there? What kind of instructions was there from the court?
Why?
We are not. My coordinate passed the order, but there is no such reflection as to what kind of
my
instruction.
lord, that is why
We are not confused. Can you tell us? Just clarify us.
Why investigating officer have not incorporated POSCO section, Lordship, like that?
no, that is.
It is okay.
I have not gone through the order, my lord, whether any there is any.
That's why I'm just also
My lord.
confused. First order heard so and so.
Right.
Also heard so and so. Case diary was called. At least on 23/4.
My lord, 23/4.
And the 23/4 leads the matter again on 6/5. That much only.
Fine.
I don't know. Was there any instruction? CDB retained.
CTV written.
So it is retained.
My
Then
Oh, not. Is there any POXO is added already?
no, perhaps not, my lord, here.
oh, Lordship's victim girl willingly accompanied with Abdullah, Lordship,
No,
and
willing-
the victim girl is returned with dignity,
with full dignity.
full dignity.
This Shamasi, whether she returned with full dignity, whether the
My lord. Lordship, may kindly bear is first of all, my lord, 183 statement, my lord. Thereafter 180, my lord.
No, just I'm just
Right.
asking one thing.
Right.
180, 183 is okay. Whether any POXO is incorporated, added.
Well, in her statement, my lord, she has not alleged any offense regarding
Acha.
that part, my lord.
That means that's not added.
No, my lord, that's why part, it is kidnapping only, my lord.
Lordship, kindly protect me. I will cooperate with investigating officer.
If 180.
Then I will take instruction, my lord, if that type of
Oh,
instruction.
I don't know. He is saying
my
we are
lord,
not in a
it's-
position to say anything. Rightly, you are submitted. Most probably there may be an observation of the coordinate bench
My lord.
that because of the girl, age of the girl. because
My
it
lord,
was
is only,
Yes,
only
Lordship.
the age of.
So POXO, probability of adding a POXO is there.
My-
Probably there. But now I don't know whether there
In
is
the statement, my lord.
adding. As per your instruction, is there any order?
No, Lordship.
180, there, 180.
What is the age of the boy?
24.
Yes, 180, my lord.
Medical was not conducted.
Then meta may be taken up as 2, my lord. I will take if required, my lord. Regarding any section added or not.
As per her, so there is no physical relation.
My lord.
Matters have already been listed at 2 p.m. So it may not be possible. Any other statement? বলবো।
Well, that is on my.
Whether they agreed for medical examination or did not agree for medical examination, I don't know.
That is,
What it has written.
that is my lord. যদিও ভিকটিম তথা তেওঁৰ দেউতাক অৰ্থাৎ বছৰীয়া ডাক্তৰী পৰীক্ষা নকৰে বুলি লিখিত দিয়ে
নকৰে।
Yes, my lord. And in a statement also, my lord, that allegation is not correct in the regarding that, my lord. That's why in 180 statement is clearly
Yes,
stated.
clearly. I have seen it.
Fine.
Let him appear and cooperate.
Fine.
You are Mr. Soria.
Be clarity, Lordship.
Mr. Big. Bishop. Cooperate. Wait, volume of when succeeded is it is submitted by Mr. Kakrai that he present his petitions. Are innocent and they have not committed any crimes as well as the further the victim has already been recovered and hence custodial interrogation may not be required for investigation. However, both petitions are ready and ready in their cooperation in further investigation. In this case, if they are granted with privilege of the arrest. Mr. Sharma will be submitted in the statement that the victim card is recovered and the statement and her statement is also recorded in section 1. Yes. However, she did not brought any allegation of physical public sexual assault. So some information methods are available. Next, being submitted with the case diary and case diary. Considering the metrics available in the case diary and also considering the fact that the victim has already been picked up his photos and then custody interview for the interview. In view of this, the present cases, I find the present. I find that the petitioners are good for the arrest with following terms. Okay, you're granted. You're granted with free arrest bail.
Chief oblige you. Lordship.
It's 34, what is the duration?
They are interim, my lord.
CD not received. CD not received, issue remanded. Interim be continued till next set of listing. Yes,
28, my lord.
28 of
23 আর জুন হইব পাৰে 28
নাথাকিব 29
নোৱাৰিব
28, you have problem?
my lord yes senior counsel will be out of station
Then second, my lord. Second.
second June
2nd of June?
oblige my lord
Orders, trial for the order.
One affidavit,
Lordship, I have already one record perhaps. Some
you have
documents,
received a copy, Mr.
some order,
Sharma?
My lord,
They have filed one affidavit.
my lord,
some trial court orders I have not annexed.
not annexed, my lord. Trial
Subsequent-
for rejection order, nahi?
No, not only rejected, all the orders, Lordship. And Lordship, just may I submit, Lordship? The case is raised, FIR is registered in the year of 2014, Lordship, and subsequently 2022, charge sheet has been submitted, shown me all the three, there are three numbers of accused, their name in the FIR, but my name is not in the FIR, Lordship. In the 2022, Lordship, my name is shown as absconder, including the other three accused, Lordship. So, my lord, in the meantime, Lordship, the charge sheet has been submitted and trial proceeding already been started. But I have not received any summon. So, my lord, NBW issued, Lordship. My submission, Lordship, I will be appear and cooperate. I am the lady,
You have not
Lordship.
received any summon.
No, Lordship. I have annexed, Lordship, all the orders. So, my lord, NBW issued, Lordship, my little prayer, Lordship, I will be face the trial, Lordship. I am the lady, Lordship.
Affidavit can assume?
Look up my
Nine.
FIR is of 2014.
14, Lordship. And charge sheet, Lordship, may come, Lordship. Page number 15, Lordship. The petition, Lordship, page number 15. And in top part, Lordship, the Walpara PS case number 28314 and dated so and so, and charge sheet number 36 2022. Dated 23 2022. Little submission is the lady, Lordship, and last 8 years, Lordship, and they are permanent resident within the jurisdiction of this police station, Lordship. But never issued any notice, even then never visited the house of the petitioner. I am protected, I will be appealed, Lordship.
One Mofidul Haq, he is already arrested.
Arrested and subsequently released on bail, Lordship. And this order is also in the, I have annexed in with the affidavit. But other not appearing, Lordship. Letter. All the accused shown, charge sheet, absconder, Lordship.
Absconder, my lord, here, lordship, page 21, my lord.
Pardon, Lord.
Charge sheet, my lord.
Yes.
My lord.
21.
Page 21, my lord.
Hmm.
Particular, my lord, charge sheet, my lord, here. প্ৰকাশ সহকাৰে মোকৰ্দমাটো উক্ত নাম ঠিকনা আসামী অভিযুক্ত কৰি সাক্ষী প্ৰমাণ মানে ইয়াৰ আৰ্লিয়াৰ অৰ্ডাৰ মানে পিছত তদন্তকাৰী বিষয়াৰ থানাত হাজিৰ ৰেকৰ্ড কৰা হয় আৰু উক্ত নাম ঠিকনাৰ পলাতক পদকীয়াগণে ভিক্টিমক ফুচুলাই অপহৰণ কৰি নি বিক্ৰী কৰাৰ সপক্ষে যথেষ্ট সাক্ষী প্ৰমাণ সহকাৰে মোকৰ্দমাটো উক্ত চয়ন They have taken her by inducing and part it was sold. That is the in the environment against they are in the during investigation they have not my lord cooperating and that's why they are declared as absconder in the charge sheet, my lord. Fulbanu baby.
one order is passed by here on 9/11/9/12/2025,
25, Lordship.
wherein it is definitely observed that a court issues summons and bailable warrant against the accused, compel their appearance, which yielded no result.
My lord.
Therefore, this court is constrained to issue
NBW.
So, service of notice or summons is not exactly here.
My lord.
But as it was not returned, so
Can be a bailable one. Initially be a bailable one.
bailable was probably issued and then NBW.
NBW.
Heard Mr. F. Hawk, the Attorney General, also heard. Mr. B. Sharma, the Attorney General, agreement status. Then application. Swens in connection. Swens. Additional affidavit has also been filed by Mr. Hawk. Next, submitted by Mr. Hawk that the present accused petitioner against. And initially her name is also was not in the FIR, but subsequently along with the other accused person, she was charge sheeted showing her as an abscond. But the present petitioner was not aware about the pendency of any case against her, as she was never searched by police during investigation. If further submitted that the petitioner never received any summons from the court and subsequently has come to the knowledge that NBW has already been issued without even service of summons. Further, if, however, the petitioner is ready and willing to appear before the learned trial court below on each and every date fixed by the court and to contest the court. Next paragraph. If some interim protection is provided. Next paragraph, Mr. Sharma, the learned additional PP submitted in this regard. That from the charge sheet as well as the other materials, it is that during investigation, sufficient materials found against the accused persons, including the present petitioner, and as they were absconding during investigation, the charge sheet has to be filed showing the accused persons as absconders. However, he submitted that one opportunity may be given to the present petitioner. No, direction may be given to the present petitioner to appear before the learned trial court below with an appropriate application for a regular. Next paragraph, hearing the submission made by the case record as well as the order sheets filed along with the additional affidavit. It is seen that the present accused petitioners along with the other person have shown as an absconder in the charge sheet. And it is also seen from the order that on 9/12/2025, NBWA was issued against the present petitioner along with others, considering their absence as the service of as the and also considering the fact that the notice as well as the PW issued against the accused person did not return after proper service. Thus, it is seen that a NBWA were issued without proper service of summons to the accused petitioner. Next paragraph, considering all these aspects of the case, including the submission made by the counsel for both sides, the present petitioner is hereby directed to appear before Attorney Trial Court below with a regular application for bail, which may be considered in accordance with law. However, when the next date is fixed, can you tell us?
12/6/2026.
However, till next date of, till 15 days of the next date of listing, next date of next date of the case, the petitioner, the warrant issued against petitioner, he stayed of the suspension with a direction to appear before Agrali Kiluni in Viladipur. Okay, you will
DPR.
be your NBW state operation is
Not published. DPR.
Yes. DSNS silo. DSNS mati dokkan, ipuli mati dokkan. So,
In this case,
and
your
who
lordship,
is, on the other side, Mr. M. Hawk is there, na?
today is the third date, my lord, he has not appeared, my lord. Your lordship will remember this
Not
had
appeared.
not appeared, the other side is not appearing, my lord. Your lordship may direct that matter be listed after 3 weeks, my lord, since they are not appearing anyway.
We can issue a notice then.
Because their name is there. In fact, my lord, the matter was listed because an application was filed by the respondent side for listing. One more opportunity may be given, my lord.
Let us do one thing. At 2 p.m. we'll take up the matter. In the meantime, we'll issue a notice also. Notice board, notice, not notice, we'll issue a
No,
notice
my
of
lord.
the board. He may appear also.
My lord.
And in case not appear, then we'll pass to your record. Yes.
Yes, Lordship. May I please to mention item number 11? For the adjournment. Yes, Your Lordship.
It was in admission call.
Yes, Your Lordship. Actually, Your Lordship, my senior is in Lakes at court number 1, Your Lordship. So it will take time. It's a date reference matter, Your Lordship, so it will take time. So
Mr. Day was on the other side.
CD is available.
CD is available.
a date may be fixed, Your Lordship.
Are you going to retain the case diary, return it, what to do? Because is any
Because they are on bail at tomorrow.
no, bail is okay. Is there any
No,
interim is operating?
no,
Interim is not. In this case, you think till when you can return the case diary?
On May 29th, Lordship.
29th, can it be retained?
No, retain, no, Lordship. We will return it.
It's 12,
No.
12th of May.
No, it will not be, how it will be updated? Very soon, it will be very soon.
The 19th.
29.
Or maybe fixed for tomorrow, Your Lordship, if kind.
No, not at all. We are not listening. It's your problem.
On 4th June, Lordship, we will update it.
Today, Thursday, my lord.
Thursday.
Ultimately, it can be disposed of.
Disposed of. It will be fully disposed of.
No, would have disposed of today also, no issues.
No.
So, okay, then 4th of June.
4th of June.
4th of June, in that case, the CD is to reach
No.
by us, maybe by 28, 29 CD is to be there. So, thereafter, there will be no progress of investigation is done.
No.
So, let it be on 4th of June then.
Obliged, Your Lordship.
the request made by the petition, the matter is that to which the additional PP and Mr. Alde returned a copy that made the respondent is no objection. Mr. However, it is submitted by Mr. Das, returned an additional PP that CD received. Full stop. Let the CD be returned for updation and updated CD may be called for. Is the matter accordingly on 4/6/2026. Full stop. IO is further directed to produce the case diary on or before the next date of listing without delay. And the way shall be made to dispose of the matter on the day of listing.
Highly available.
Yes.
May I please, Your Lordship?
no, no,
Report
that's
was called.
Yes, 27 was, yes, important.
One report received, my lord. Case number is, Your Lordship may kindly peruse the report. With due respect in front of the subject matter available at the police station, no case has been found registered against the above mentioned person at Bagbor police station. But who is the above named person, my lord? That is case number. He has mentioned 620. Hurriedly, my lord, he has sent this report. There is case number mentioned.
So case number, case.
We have sent the photocopy of the first page of the petition while thereafter, my lord, along with the name of the.
I have named person means who's which person.
Yes, the report is
Case
not.
number is also not there.
Yes. Then
We
Your
have
Lordship,
received the report, but report is a very big report because there is no case number that apart. If name of the petitioner is also not mentioned.
Yes, sir.
Your Lordship may
So
fix
in
it
that
day
case,
tomorrow, my lord.
when?
Day after tomorrow, I
No,
will.
no, it we are not listing. We have some, we are listing less numbers.
Oh, yes, yes.
Maybe by 11/12 we can.
Oh, yes,
list it.
12th of May.
12th of May. But it has to come from Bagbor, no?
Bagbor.
Lordship,
Better.
kindly fix it another date because 12th of May I have another case in Nagaon. So it may be possible on before 10 or 11.
Date we are not fixing. 19 is holiday. 11 is Monday. 12 we have.
12 I
some
have
matter- 12.
another case in Nagaon. So it's may possible 13 or 14.
Let it be on 13th then.
Yes.
Okay. One tree good. This hard swings Mr. Nath Waterford. It is submitted by Mr. Waterford and one report is received from Bagbor police station. But there is no mention about the name of the petitioner or the case number. And hence it is difficult to come to a conclusion as to whether any case has been registered or not yet registered for the petitioner. In view of this, let a fresh notice report be called for from the concerned police station. And notice may be accompanied with this one. This accompanied with by whom? Which?
Officer in charge police.
No. Accompanied by the cost title of the petition or what do you want?
Yes, yes.
Okay, maybe accompanied with the cost title of the petition. IO is the officer in charge of Bagbor police station is directed to furnish the report on or before the next date. List the matter accordingly on 13/5/26. Interim be continued till next.
My school.
May please, Your Lordship. Lordship will find the FIR at page number 11. Lordship-
32, there was some submission, yes.
My lord.
some,
Allegation-
submitting.
My lord.
No, CD receipt, na?
CD receipt, my lord.
Okay.
Lordship already placed the 180 statement, my lord. He has appeared, but after appeared, he has taken some other views, my lord.
Oh,
That is
yes.
okay.
Yes, yes, Mr. Mehdi.
Lordship.
Yes.
Lordship, the allegation against me is this, that on 22/2026, while the complainant was attending the call of nature at around 3:30 a.m. in the morning, I have attempted to rape her. Lordship, this is a false allegation. My humble submission is this, Lordship, that I was morally wrong. She is also married. I am also married. We were in a relationship, Lordship, and Lordship, it was a consensual thing. When I came, I was the husband of the complainant. When he came to know about this incident, he instigated her to file this complaint against me. And Lordship, I don't know what has come in the CD, but I have, Lordship, I have cooperated with the investigating agency. I had appeared after receiving the interim order, Lordship, I immediately went to the police station. I cooperated. And Lordship, in future also, I will keep cooperating with the investigating agency. My humble prayer is this, Lordship, my custodial detention may not be required, Lordship.
Now, yes, Mr. Shah.
My lord, here, as per my lord, 183 statement, my lord, she has categorically implicated, my lord, as whatever she has explained in the FIR, my lord, that I reiterate in the, my lord, 183 statement, my lord, implicating the accused person. He tried to,
I mean, what I have seen in 183, she brought some allegation against you.
Lordship.
You were trying to grab her, by
Lordship,
grabbing her,
Lordship,
you're trying to
Lordship.
so and so. But in this the statement made by the accused is quite different. He brought another story. He
Lordship.
went for function.
my lord,
Function there has
That
it happened. This kind of things. She
relationship
brought.
was there as per the instruction I have received, Lordship. It is apparent that there was some kind of relationship with them between the both of them. Otherwise, at 3:30 a.m. in the morning, Lordship, because I knew that at 3:30 a.m. she was supposed to come out and meet me. The rest, Lordship, I rest my case and I leave it up to your Lordship. Lordship will be in a better position to adjudicate, Lordship. I'm just
Directly, there is no case of allegation of rape against you, but
Lordship.
you tried to.
Lordship,
That is the
Lordship,
allegation.
Lordship.
in his statement also, he said that, my lord, there is a love affair between for last 6 years or that.
I admit, Lordship, morally I am wrong.
Part Mr. P.P. made the done counsel for the petition. Also, part Mr. B. Sharma, the done petition P.P. appearing on behalf of citizens. It's an application section Swens in connection with Swens subsidiary received credit receipt. Submitted by Mr. Mehdi that the present accused petitioner and the is a fact that the present accused petitioner and the victim had some love relationship. And though it is morally wrong as both the petitioner and the victim are the married persons. On the day of incident also, when the husband of the informant came to me about the relationship, he insisted to lodge an FIR. But there is no such incident took place as alleged in the FIR. However, after getting the order of interim, he appeared before the IO, cooperated in the investigation, and his statement is also recording the record. Mr. Sharma did an additional PP submitted in the check that the in 180 in the statement made by the victim in section 183 and 180 BNSS, and she brought the allegation which brought the allegation of attempt to commit rape on her, rape on her post. However, the accused petitioner appeared before the IO and cooperated in the investigation, and his statement is also recorded. Next, considering the submission made by counsel, I have also perused the case diary, considering the materials available in the case diary, statement of the witnesses as well as the this court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. In view of this, and it is to extend the privilege of pre-arrest bail to the present petition, and accordingly the order of interim pre-arrest bail dated 27/03/2026 is hereby made absolute with same terms.
I'm deeply obliged, Lordship.
We have given the notification,
It was there, Lordship.
but did not appear, I think. At that time, Mr. Nawaz has also submitted.
Yes, Your Lord. Lordship, in any case, as per what we had discussed, Lordship may fix it after 4 weeks without giving a date. Then in case the party again comes, the petitioner, respondents again come, they can raise the issue accordingly.
because
After 2 weeks, after 3 weeks.
3 weeks, sir.
Mr. M. Hope was yesterday also, he was present in the court. I may not get any instructions, I don't know.
Even on, I think, Lordship, last 2 occasions also,
No, he
was-
remained absent.
yeah.
There's no one has represented.
we were also not intimated about any of.
For Mr. A. Mishra, a learned counsel petition. State is not the party here, no? And no one has represented the respondent. So the name of Mr. M. Hope is reflected in the cost list. From the record as well as from the submission made by the learned counsel for the petitioner also, it reveals that on the last 2 occasions, the petitioner, the respondent remained unrepresented. Full stop, however, for the ends of justice, one more chance is given and let the matter be listed after 3 weeks. And in absence of the respondent, the consequence order will be passed. Please take it.
Lordship, let it be on behalf of Mr. Esnavas.
Okay, your name is not there, no?
No,
A. Mishra appearing on behalf of Mr. S. Nawaz.
I'm deeply obliged.
You want to- Please, sir. Oh, I'm already picked. তাহলে মোর এয়ারপোর্ট নকল এয়ারপোর্ট টাইমিংটাও না জানি কোন ভাড়াটা করা হবে বাকি এটা পরে করি ওলা গতিকে 15টা কই দি nine
May I please your lordships?
who is looking at 9 you are
My lord, in the present case, my lord, I have filed this email petition for quashing the my lord FIR as well as the my lord the PRC case number, my lord, that is pending before the runner as design number 2 of Kamrup Metro at Gauhati, my lord.
case is not
In
yet
this
charge
case,
sheeted, na?
my lord,
Case is not yet charge sheeted.
charge sheeted, my lord.
Is it charge sheeted?
Yes, my lord. And there, what happened under section, my lord, 279 and 338 of IPC, my lord. 279 and 338 of IPC. The present case is filed, my lord, jointly, my lord. In this case, my lord, the petitioner number 1, my lord, that is the rider of the offending motorcycle, my lord, and the petitioner number 2 is the informant, my lord. And petitioner number 3 is the my lord, that is also an injured person, my lord. And in the present case, my lord, there was head-on collision in between the my lord, 2 motorcycles, my lord. The petitioner number 3, as well as the my lord, petitioner number 1, my lord, they were riding motorcycle from my lord, and the head-on collision took place in the year of 2024, my lord. And immediately after the accident, my lord, the father, that is the my lord, petition number 2 is the father of the petitioner number 3, that is the injured person. And both the my lord, rider, my lord, sustained injuries, my lord, and both were undergoing medical treatment. And there was some amicable settlement at the time of my lord, medical treatment. And subsequent, my lord, in the meantime, my lord, FIR has been lost. And accordingly, FIR registered, my lord. And that's why, my lord, officer in charge, my lord, subsequently declined to accept their compromise, my lord. And subsequently charge-sheeted and now, my lord, pending before the learned SDGM 2, my lord, at Kamrup Metro, Gauhati.
Lordship,
In this
what
case,
is
my
the
lord,
stage of the case?
My lord, now is appearance stage,
Appearance.
my lord. Yes, yes, my lord. I have submitted, my lord. It looks.
Even
Yes, the judgment is I will think. As the, my lord, matter has already been, my lord, amicably settled in between the parties, my lord. And my lord, section relates to, my lord, 217 and 338 only, my lord. And there was injuries of both parties, my lord. As I have my lord, submitted, my lord, 3 numbers of, my lord, judgment passed by your lordships, my lord. First one is, my lord, criminal petition number 212, my lord. In that sections, your lordships is passed order. But in that section, in that case, my lord, section relates, my lord, 279 and 304A, my lord. It's more, my lord, some serious, my lord. And my lord, and second one is, my lord, that was, my lord, criminal petition number 519/2025. Second one, my lord. In that case also, my lord, jointly filed, my lord. Jointly filed by the accused petitioner as well as the, my lord, mother and father of the deceased son, my lord, victim, my lord. That case has also been, my lord, quashed, my lord. That is PRC, my lord. That, my lord, your lordships, there are some other judgments also, my lord. I would not like to go through all the judgments, my lord, because, my lord, already been amicably settled, my lord, matter.
yes.
There is no, my lord, chance. Already, my lord, the injured person himself, my lord. I have submitted, my lord, 2 numbers of affidavit also, my lord, showing their 2 numbers, my lord. First one is page 717, my lord, 17.
That is by the informant.
By the informant, my lord, father of the, my lord, injured person, my lord. He has also stated, my lord, very specifically stated that he has no any objection, as the matter has been already amicably settled, my lord, earlier. And, my lord, second one is, my lord, by the, my lord, injured person himself, my lord. So, my lord, in the present case, my lord, my lord, there is no any, I think, my lord, no chance of, my lord, conviction, my lord. And very
Just
remote.
tell us one thing, and this affidavit is sworn by Aziz Ali, that is the accused petitioner number 1.
My lord, sorry, my lord.
The affidavit which has been annexed along with your petition
Yes.
is sworn by Aziz Ali. That is the petitioner, I think.
No, my lord. Affidavit is shown. No, my,
No,
in
no,
my
the
petition.
yes, yes.
Uh,
Along with
yes, it's petition number 1, my lord.
So where from we'll come to know that the other 2 petitioners also is the petitioner in this case? Is there anything? You have submitted 2 affidavit.
Yes, my lord.
I can see. One by the informant and another by the.
Yes, yes, my lord.
But is there anything to compare the at least thing otherwise? Because the original FIR you have submitted, original FIR?
Original FIR, my lord, I have submitted, my lord. That is at page, my lord, relevant portion, my lord, page 14, my lord. Page 14, 1-4.
Now see, our problem is that one Ranju Kumar Bora made a signature here.
Yes,
You
yes.
can see.
Yes, ma'am.
In the FIR.
Yes, my
But
lord.
it
I have
is in SMS.
Yes, my lord.
It is in SMS.
I have
and
also
in a very good handwriting, he put his signature
Yes.
in affidavit.
Yes.
One by Ranju Kumar, that is the father.
Yes, ma'am.
Or the informant, and other one by his son, Bonjit.
Yes, ma'am.
So
if possible,
there
my
is
lord,
nothing for us.
then, my lord, another date may be kindly fixed for. On that, my lord, I'll file additional affidavit before this honorable court. By the petition number 2 and 3, my lord.
That can be done.
Yes, my lord.
Yes,
Lord,
what
that will be
submitted.
better, my lord. Otherwise, I have also seen, my lord, the signature is, my lord, in Assamese, my lord. In
Or
affidavit.
that's why I was
Yes, my
looking
lord.
because of the affidavit.
Yes,
If
yes,
affidavit would have been sworn by 1 of 2 or 3, then it's okay. But affidavit is sworn by you. I mean,
yes,
petition number 1.
additional affidavit, my lord. I'll file.
Yes.
One more thing, Lordship, whether section 279 and 338 IPC, those sections are compoundable.
Non-compoundable, but
That's
even
why they
after
have come.
528, this is, my lord. This petition is 528, my lord.
That
Not
is
compoundable,
not
that's why they have appeared
Yes,
before.
that's why.
This is the case. So let him file
Yes.
one additional because there is nothing now
Yes.
before us. That's why I just try to compare
And
the
Lordship, in the
signature of
meantime,
Ranju Kumar.
TCR is not before us, Lordship.
Nothing.
Nothing.
No,
has
no
been-
one
so
is
in
here.
the meantime, Lordship may call for the TCR also.
TCR we have not received.
Not received, Lordship.
Maybe call for us. Here is my lord. TCR my lord in Kamrup Metro my lord.
I guess it will come in the meantime. You file your addition.
My lord, my lord.
Hard Mr. Yes, Amit, Mr. Sorry, message for regarding the addition of me, appearing on behalf of state respondent. Hearing the matter some length, it is submitted by Mr. Ahmed that he will file an additional affidavit. Additional affidavit that trigger full stop. Same time, it is MS Bora submitted that the scan copy of the TCR may also be called for from the learned record. In view of this, let the matter be. How many weeks you need?
My lord, 2 weeks, my lord.
You want any fixed date?
My lord, I fix. Kindly may have the date of the
28th of June.
May,
28th of May.
May, my lord.
28th of May corridor enabling the petitioner to file his written additional affidavit, and in the meantime, the registry will also call for the scan copy of the TCR. So registry will do the need.
My lord, additional affidavit by petitioner number 2 and 3 or all petitioners, my lord.
I have just submitted the additional affidavit by 2 or 3. You can
My lord, my lord. Obliged, my lord.
May it please your lordship, the learned counsel is on leg. The item may be passed over for time being.
Let's see. We'll pass over for the time being. If other matters is then I cannot say. Then I cannot say, but it is okay then. For timing, we are keeping it.
My lord, here, in an NIA case, petition was convicted by the trial magistrate, my lord. Against the conviction order, my lord, petitioner preferred an appeal before the learned district judge, session judge, that was dismissed. Against the dismissal of the appeal, my lord, the petitioner approached this court by way of a criminal revision, my lord. Now, during pendency of the criminal revision, learned trial magistrate, my lord, again, my lord, passed PNA order against the petitioner since this court, my lord, did not state the Indian judgment of the learned trial magistrate. So that PNA order has been challenged before this court by way of a criminal petition, that item number 12, my lord. Now, during pendency of the criminal revision and criminal petition before this court, my lord, both the parties, since the matter is an act matter, my lord, both the parties have amicably settled the matter. One compromise deed has been my lord, entered between the parties, and my lord, part payment has been made, my lord. Now, at this is my humble prayer, my submission before lordship. At least during pendency of the criminal revision, my lord, at least the PN order is passed by the learned trial magistrate, that may be stayed only. That is my submission, my lord. But the agreement between the parties, my lord.
What do you want to?
It's a settlement deed between the two parties.
Lord,
You are not aware of?
yeah, I'm appearing on behalf of Hassan. He is out of station. Engaged counsel is Hassan. He is out of station. So he instruct me to inform the court that criminal petition may be disposed of, but the criminal revision
may be kept pending.
No, criminal petition he is seeking.
Yeah.
That why PNA up to PNA? Why court had gone up to PNA?
Yes, my lord. Because my lord, since the judgment, impugned judgment, that was not listed by this court, my lord, or even the appellate court also. So ultimately, the learned trial magistrate put up the record.
No, it's okay. I can understand.
And
so I'm asking that
initially passed NBW order. Even the petitioner, the present petitioner, is a employee of railway employee, permanent resident of Maliga also. Earlier, probably warrant was issued, that was not executed by police, then PN was issued.
So in criminal petition, have you annexed the orders?
Yes, my lord. Criminal petition 2 to 6, my lord. Lordship will find 12 to page number 14, all the orders, my lord.
From page number 14?
Yes, my lord. Starting from 12, Lordship will find page number 12, the first order, 6/8/2025, CR put up today the case record is received back from the Court of Honorable Session Judge Kamrup Metro Gauhati, along with the judgment passed by the Honorable Court dated so and so in criminal appeal number so and so, received by memo number so and so dated so and so from the Honorable Court of Session Judge Kamrup Metro Gauhati. I have perused the judgment dated so and so, whereby the Honorable Court hold that this court had rightly convicted the convicted accused person beyond all reasonable doubt, and accordingly pleased to uphold the judgment passed by this court. However, the accused person is absent without any step issue NBW against the accused. Well, since before issuing this order, well, no summon or notice was issued to the this present accused petitioner. So ultimately, it is not possible on the part of the petitioner also to appear before the trial magistrate. Anyway, the next order is, my lord, 10/2/2026. This order was issued issuing, my lord, PNM. Earlier NBW order, then PNM. Then yes, yeah. And on the same date, my lord.
No, 2210.
Uh,
It was fixed on 22/10/2025. Where is the order?
Yes, the order is page number 13, my lord. And on the same day, page number order 13, on this date, my lord, when I came to know that the NBW was issued against the petitioner appeared before the trial magistrate, filed a petition stating that a criminal revision has been filed before this court and the criminal revision is pending. So at least during pending of the criminal revision, the Honorable Court could consider my application and recall the NBW order. But that petition was not allowed.
Yes, because there was no stay order.
Yes, my lord, only for that, no stay. So subsequently, my lord, both the complainant and the accused, my lord, amicably settled the case and, my lord, entered into a compromise. So since the matter relates to NI Act, my lord, and so for section 145 of the NI Act is concerned, if I am correct, my lord, so it is a comfortable offense and both the parties have amicably settled the case, my lord. So at least, my lord, criminal revision may be kept pending, my lord, since part payment has been made, but the criminal petition that is relating to, my lord, PNA order, that may be, my lord, considered today itself, my lord.
Then do one thing, this revision is pending.
Yes.
Suppose if any compromise is there, one part payment has suppose made.
Yes.
Then the further pendency of this revision before this court may also doesn't carry any value such. And so direction can be made with the two parties to appear, but his counsel is not there.
Yes, ma'am.
Today. Okay, then we can dispose of the criminal petition.
Yes, criminal petition may be disposed of.
But that in that case,
Quashing the PN order.
No. What is the PNA order? But your direction will be there to you appear before the. Otherwise, what order? Because you don't have any stay order with you.
Yes, madam.
So, in that consequence, what will happen? Simply staying of PNA will not do, na. Staying of PNA will can be passed the order, stay of PNA and the NBD. But your direction has to be there to appear before.
Otherwise, my lord, both the petition may be kept pending, but that order may be suspended for the time being till the next date. The order passed by the learned trial magistrate that may be suspended. The operation of that order may be suspended, and both this criminal revision and criminal petition may be kept
till
pending.
next date of listing. It can be
Till next date of listing.
Otherwise, you have to be.
Yes,
you have to appear. There have to be some direction
yes,
to you for appearing.
Both the petition may be kept pending, but the operation of that order may be kept suspended.
Criminal petition order often available yeah. Criminal petition today. You are Mondal or Islam? Islam.
MA Islam.
Hard Mr. MA Islam. In revision petition, you are the respondent. Yes.
Complainant respondent.
এটা দুটো এক লাগে no না লাগে পারি card Mr. M.A.S. regarding conflict with the petitioner. If they look then also card, we are hearing you only. Because there is a court's order against the court's order they have come.
Lordship,
So rightly they have implemented the state as a respondent here.
Lordship. And Lordship,
So what
kindly
we'll
come
do-
to, subject to correction, come to page 14, Lordship.
1-4.
1-4. Order dated 10/2/2026, Lordship. I have found no illegality in the said order because Lordship,
Yes, there is no such illegality because
Yes.
stay order is not there, so that's why they sent.
yes,
There's no kind of illegality.
no illegality. And the
Because
next
in
date is
first day
Lordship.
itself, they did not obtain any stay order from this court
Yes, Lordship.
to produce before this. So rightly passed.
Yes.
We are not disposing the criminal petition. We are
Yes.
simply considering the part payment made by the between the parties. We are staying till next date.
Yes. And Lordship,
are-
the next date is fixed on 26/05/2020.
26/05. Prior to that, it has to be listed.
Yes.
No, my lord, actually, obviously, if that
report.
order is state, my lord, if the order of the learned trial magistrate is state, obviously this order will be placed before the learned trial magistrate and the learned trial magistrate will.
So we
take
cannot
part.
pass any stay order in your criminal petition.
No, Lordship.
There's no
That-
prayer.
that
You
I'm-
cannot pass it. At best, we can stay till next date of listing. If there is any progress, any development is next
Yes,
date.
madam.
That then direction can accordingly be passed for your appearance or whatever.
Yes, madam. Only that direction.
Mr. M.A. Islam, the learned constituent also academics. S.H. Bora, the learned edition PP, appearing. Even is submitted by Mr. Islam that after disposal of the criminal appeal, the petitioner was directed to appear before the learned trial court below. But before his appearance, the learned trial court below, on receipt of the case record from the learned appellate court, had passed the order of issuance of NPWA against the present petitioner on 6/8/2025. On the and on the very next day, that is on 10/2/2026, the NPWA along with PNA standing warrant along with the PNA has been issued against the present petitioner. Present petitioner, full stop. The further submitted that on the very next day, the PN order of PNA was issued against the present petitioner. But present petitioner. Secondly, Mr. Islam, further Mr. Islam submitted that during the pendency of this criminal petition and the connected criminal revision petition 311/2025, the parties has come into a settlement, and in view of the in person to that settlement, part payment has already been made, and the rest of the payment is also going to be made in installment basis. Mr. Islam accordingly submitted that till next date of listing, the order of issuance of PNA and standing warrant may be kept in appendix. Next para, MS Fora, the learned additional PP submitted in this regard that no illegality has been committed by the learned trial court below while passing the order of PNA and NPWA, as the petitioner did not appear before the learned trial court below, nor could produce any stay order of this court. Next, we are considering the submission made by learned counsel for both sides, not only considering the fact that there is a settlement between the parties, let the execution of order dated 10/2/2026 be stayed or suspended till next date. Your petition is 26/5, na?
But
prior to
my
that,
lord, mostly in the compromise agreement, I think there are some dates, my lord, there is a time schedule for
we're not going to dispose the entire matter, so I just manipulated your. I just narrated your submission. 26/5 or 20. 20 will do. We'll try to dispose of the matter on 20. And by that time, if any other development is there, any part payment is there.
No, my lord, possibly, my lord, because there are two cases. One is filed by wife, that is before lordship. The other is by husband, that is pending before the trial magistrate. So both the cases have been settled, and amount is a very big amount, almost near about 5 lakh rupees, my lord. So I have the only one that I have submitted before lordship. Most probably 3-4 months. I think there is a time schedule for complete payment, my lord. So within 20th or 20 before 26, it is not possible. It may not be.
Why we are fixing? Because for disposal of your criminal petition,
My lord.
by on that day you may seek for your stay order also.
My
That's why we are fixing it on 20 of this month.
So in between, my lord, the at least at this instance, my lord, that order may be.
Yeah, we have stayed.
Yes.
Suspended. We have.
Yes, ma'am.
This type was happening. 20.
Yes, ma'am.
And it will করে দিব আর you are Mr.
K. Kolita. On
K.
behalf of
Kalita.
KM.
Criminal division to দিব A. Islam দিব আর Mr. K. Kalita appearing on behalf of Mr. K. M. Hassan list the matter accordingly on 20. Both the matters we are listing it on 20.
High level.
Out I think I said. Hello, Bob. 14 state is there.
May it please your
Yes.
lordship. Your lordship, the present matter is pending before the Honorable Trial Court at Bajali at the stage of consideration of charges. Your lordship, this is a charge sheet case. And in this present matter, an FIR was lodged at Patshala in the year 2024, 8th of February, alleging discrepancy of 63 command certificate from Home Guard volunteer. Your lordship, I have been falsely implicated in the present case only on the statement of the co-accused. Your lordship, I filed a discharge petition before the Honorable Trial Court, which was rejected primarily on the ground that the co-accused during investigation has taken my name. Your lordship may kindly peruse Annexure 7 of the rejection order in page number 62. May I read the relevant portion, Your lordship?
So you are against the order of rejection.
Yes, Your lordship. Your lordship, in the petition, it is stated that there are no incrementing material against the accused in the charge sheet or in the statement recorded by the investigating agency under section 161 of CRPC. Though the charge sheet has been submitted under section so-and-so of the IPC, it is further asserted that the petitioner is not named accused in the FIR and the charge sheet does not disclose the essential ingredients of the alleged offense against him. I have perused the petition, heard learned defense counsel for the accused, so-and-so, as well as the learned APP for the state. I have carefully gone through the charge sheet along with the statement of witness recorded during investigation. On the perusal of the statement, particularly the statement of the co-accused, it appears that the co-accused has specifically taken the name of the present petitioner regarding his involvement in the commission of the alleged offense, and the same has been duly reflected in the charge sheet. At the stage of consideration of charges, the court is only required to see the prima facie cases made out against the accused and not to conduct a meticulous appreciation of evidence. The material available on record at this stage disclose sufficient ground for proceeding against the petitioner. Hence the case, Your lordship. Your lordship, I want to submit that no prima facie case is made out, as there has been no recovery whatsoever from me. Neither any monetary transaction has been found, and your lordship is well relevant to the settled principle of law that the statement of co-accused is itself has no evidentiary value unless corroborated by an independent material.
So thereafter, your charge is framed against you.
Yes, Your Lordship.
It's pending in the stage of consideration of charge. Not yet.
Not yet.
Not yet. Next date is fixed on 26/5/2026.
So you're basically saying that there is no recovery.
Yes, Your Lordship.
And any other?
And no monetary transaction can be seen. And Your Lordship, I'm just a home guard. So Your Lordship, I don't have the power to issue such command certificate, which is the material in discrepancy in this case. And Your Lordship, I was already posted back to Gauhati when this incident happened. So I was working in Kamrup Metro. And right now,
Incident had happened in which place?
Your Lordship,
Incident had happened in which place? Patshala.
Patshala, Your Lordship.
Yes. What?
Lordship, in the FIR, the contents of the FIR does not disclose the name of any of the persons, Lordship. Lordship, kindly come to page 15 of the petition. It has been alleged that it's an organized crime, Lordship. May I read?
Yes.
With reference to the subject cited above, I have the honor to inform you that 63 command certificates of Home Guard volunteers were received at Police Reserve Office, Wajali, since last few months, which was output. In this regard, later addressed to the Commandant, Home Guards, Urban Wing, so-and-so, sent through the Superintendent of Police, by later dated so-and-so, for verification of 63 Commandant certificate. After duly receipt of the verification report, it has come to notice that only 16 Commandant of certificates are issued by the Commandant. Other rest are Home Guard, Urban Wings, Barpata. You are therefore request please to take lawful action against him who has issued the fake command certificate to the Home Guards volunteers at the earliest from your hand. So to that regard, Lordship, during investigation, Lordship, sufficient materials has been found against the present petitioners on the basis of the statement of the co-accused. And Lordship, at the it is the court has to see at the stage of discharge petition while deciding a discharge petition, only no roving inquiry of the or total appreciation of the evidence is not required by the court. Only the prima facie case has to be made up. So that has been fulfilled. Lordship may kindly peruse the search sheet where the during investigation materials has been found against the petitioner, and so far as the CDs is concerned, that is Lordship, I have not found the complete CD. The statements of the co-accused as well as the other. That is not, perhaps
Not
that is not there. I have gone through the case record, Lordship. Only the copy of search sheet is there.
Because from there only you can
Yes,
submit something, whether there is any
Yes.
privacy,
But-
whether there is.
yes.
Also, because if you see the FIR, there is no name. Obviously,
No
there
name.
is no name.
Yes,
And admittedly, he is also working as a home guard.
Lordship.
So there may be some connivance with.
Connivance with
the
other
thing.
associates, Lordship.
But that has to be there from
That
the
has to be looked
statement,
into
maybe
from the
to-
statements of the other co-accused
Yes,
as well
but
as
if
the
it is
witnesses.
not there, then we have to.
And since the forgery is also concerned, Lordship,
Hmm.
because 468, 470.
Yes, the signature was question of signature.
He might
is
be a
there.
home guard, but how he is
Be a home
connected,
guard, but
the
what-
complicity of the present petitioner has to be looked into.
Oh, here to particulars of case record on the PRC.
Only the 164 statement of some of the victims I have found, Lordship. And a copy of.
No, copy of
Search sheet.
CD is not there.
Not there, Lordship. Only
These
copy
are
of
the
search sheet.
only charge and search sheet will be there because these are the materials which were furnished along with the charge sheet.
Lordship.
So these are the their charge sheet and the copy of the
And the CD part is
164 etc.
not
These
there.
are there.
Have not
But apart from that, the CD is not here.
Yes. And
CD is
few
not.
statements of the victims under 164. Lordship.
It is accompanied with the charge sheet.
Yes.
That's why it is here. So it
So
is
that is required
mistakenly
perhaps.
on the part of the learned trial court who send the scan copy, most probably the order also. Generally, when I pass the order, I used to mention along with CD.
CD, yes.
But here, most probably inadvertently, that was not there. Only this scan copy of the TCR was called for.
Yes.
So that's why it is not accompanied with the case diary.
CD has to be there, Lordship.
It has to be there, or your perusal is required. Otherwise, how can you submit?
Yes.
There may be materials, there may not be all
Yes.
as she submitted. You are MS?
NN Hussain.
And NN Hussain, na?
Yes, Your Lordship.
Hard MS NN Hussain, the learned counsel for the petition. Also hard MS SH for learned additional PPF on behalf of state respondent. Time of hearing the case report, at this point is submitted by Mr. MS Bora. That only the scanned copy of the DCR is being received, but there is no copy of scanned copy of the case diary, which will also be required for disposal of the same. On perusal of the record, it is seen that the learned trial court below had sent only the scanned copy of the DCR, and it is not accompanied with the scanned copy of the case diary. In view of this, the registry is hereby directed to issue reminder to the learned trial court below to send the scanned copy of the case diary along with the present status report. Registry will do the least record 25th of this month.
Highly obliged, Your Lordship.
Yes, 15, who is looking?
May it please, your lordship.
No. Yes, you are seeing 15?
Yes.
Okay. Yes.
My lord, here is a case, my lord, the petitioner number 2, my lord, eloped with the petitioner number 1.
Petitioner number?
2, my lord, eloped with the petitioner number 1. Her father, my lord, lost the FIR, alleging, my lord, kidnap. They have already got married, my lord. The boy child has also been born, my lord, out of their wedlock. And they are, my lord, currently, my lord, living peacefully, my lord, as husband and wife. And the informant also, my lord, he died in the meantime. So, my lord, there is many judgments of this honorable court, my lord, wherein this type of cases has been interfered with by this honorable court, my lord.
Father is no more?
Father is no more. I have also annexed a similar order, my lord, at page 43, my lord. Wherein, my lord,
She was a minor at the relevant time. But case has only been registered under 66.
Okay.
you are more.
Chancellor. Lordship may call for the status report.
What is the stage of the case at present?
My lord, against the NBW only, my lord, came initially, my lord. The NBW has been issued, my lord, because, my lord, he was, as they were, my lord, living husband and wife, he was under the impression, my lord, the case was closed.
Acha, you have come with the
I have also challenged the entire proceeding also.
No, you're saying NBWA?
NBW orders are also there, my lord.
Only seeking quashment with regard to the orders.
As well as the proceeding.
Only quashment of the order or proceeding?
Order as well as the proceeding, my lord.
And the acquired. Proceeding.
Paragraph number 3, page 11.
To substantiate your plea, what you have been annexed, is there any annexures? Your marriage?
My lord, I have annexed the birth certificate of my child, my lord, Case 42, my lord.
42.
42, my lord. The child was born on 24/1/2023, my lord. Name of the father, Abdul Ali. And name of the mother is Tamim Sultan.
Charge sheet, you have NXT charge sheet also here? You have NXT charge sheet also. We have received the scan copy? No.
Lordship,
Scan copy. we have
scan
received?
copy not received.
Okay, call for the scan copy.
So your further proceeding is remain state.
My
Yes.
You have the charge sheet also, you have not submitted. So what I want to say, just frankly, I'm saying, you have submitted and here it is, you have, as per your petition, case is charge sheeted only under section 366.
Yes.
In that case, it seems that there is no addition of any POXO and also
So it is there.
we don't know at this stage whether POXO is there or not. That's why if POXO is there, definitely, obviously your informant of the victim is the petitioner here, no doubt about it. It's okay. But still, we need something. But here you have not annexed
Okay,
the
call for the scan
charge sheet.
copy. Okay, call for the scan
You have
copy.
pray for you have prayed for the quashing of the FIR charge sheet also,
Charge sheet also.
and you have not submitted the copy.
Well, entire proceeding I have challenged. Entire proceeding.
Now, particularly charge sheet you have challenged. Is there any challenge of your charge sheet?
No, Lord.
Then
No.
wherein it is report stated that your entire proceeding is been challenged.
My lord, page 11, my lord.
Page 11.
My lord. Para number 3, my lord.
So as per your thing, it is 366.
My lord.
So it seems that during investigation, the girl was maybe a measure also,
My lord.
but we do not know anything.
We do not.
Let the entire case record be called for that.
Yes.
At least this year be called for.
Yes.
Because you have already enjoying this stay order.
Fine.
Let the this year, let the
My lord.
record be paid.
Yes.
Otherwise, we are not in a position to say
My
anything.
lord.
Yes.
There may be addition, there may not be. Part Mr. I.H. Saikya, the running petitioner. Sorry, I'm S.H. Bora, so and so. And hearing of this criminal petition, it is seen that the scanned copy of the DCI is not yet received by the court, which will be required for the disposal of the present in view of this. Let the scanned copy of the DCI along with the present status report be called for. Rest you will do the needful. Is the matter according after 2 weeks we'll do.
My lord.
After 2 weeks, as on a date.
Interim order will be continued.
Interim be continued till next.
Obla.
Lordship, on behalf of SC Wishes, I am praying for adjournment today, Lordship. He has left the court due to personal difficulty. On behalf of SC Wishes, I am praying for adjournment today. He has left the court due to some personal difficulty.
There are, you are also appealing, yes.
This is the maintenance case, my lord.
Maintenance.
Yes, my lord. That's why, my lord. A petitioner, respondent wife and the child, my lord, only 15,000 is getting monthly pension. Maintenance at present, my lord. Whereas a husband is drawn a handsome salary at about 70,000 as on today, my lord. And
So you were also asked to file your latest salary statement.
Yes,
the
Lordship.
last court.
On last occasion, your Lordship direction was to file a salary statement.
That you have already filed. And shall continue to pay an amount of 15,000. Have you paid the amount also? Your maintenance amount, is there any payment of your maintenance amount? Because last order, it reflects that 15,000 was directed to pay.
Lordship, I have no instructor
no
reading
instructor.
this. Like,
Why some personal difficulty, he had to leave.
And then Friday, my lord. Friday or next Monday, my lord.
Friday?
Monday, my
lord. Let us verify. He's saying addressed on 14th.
4th.
1/4.
1/4, 14.
14. 1/4, 14.
So long, my lord.
Too
So
long.
long.
Then we'll give you on a 28/5. Huh? Long haul.
This is the main reason. Some problem arise, my lord. Children is going to school, my lord. Some
I
problem.
can understand.
Yes,
That's why
my
I'm
lord.
just
Short
asking
date may be
repeatedly
given.
hard. Have you received 15,000?
15,000 already received me.
You have received?
Yes.
It will help you to some extent at least.
Yes. Somehow,
Maybe to some extent. You are MS?
Debashree Chakraborty.
D. Chakraborty.
D. Chakraborty.
Our MS D. Chakraborty appearing on behalf of Mr. S.C. Biswas. And it is submitted that due to some personal urgency, Mr. Biswas had to leave court premises. Also heard Mr. A.M. Ahmed, United Council for the response. Submitted that matter is urgent as the petitioner, the response is not getting maintenance allowance, and for which she is in a very difficult position to maintain herself along with each. Let the matter be accordingly listed 40. 1/440.
Grateful, Lordship.
I'm sorry, Lordship, I was in other court.
It's okay.
May please, Lord.
Yes, but it is a criminal petition, na?
Sorry, Lordship. Yes, it is a revision under 19.4, Lordship. Sorry, Lordship, 528 BN, passed by Honorable J.
Petition. Yes, Lord.
PCR have received, Lordship.
State is not the party. I think only the private party.
No.
Yes, what is the case about?
Yes, Lordship. The petitioner, before the Lordship, has challenged an order passed by the Honorable JFC, whereby a maintenance was granted as 10,000 per month to the respondent wife. Initially, the case was rejected. The learned JFC has initially rejected the claim of the respondent wife. Thereafter, against that orders, he have preferred a revision before the session court. And session court has directed the JFC to decide the case on the point of quantum.
So JMFC earlier initially rejected.
Rejected under 125(4). There are certain allegations regarding adultery and all, and those some WhatsApp conversations are in the trial court record.
So by revisional court, it was directed to decide the quantum.
Only the quantum. So at that point of time,
while passing the order in revision, there must have been some observation that because you are saying that 125(4), it was initially rejected by the learned GMFC.
Yes, sir.
So is there any observation in the revisional court order?
No, there is no revision as regard to the quantum.
No. I'm not on that. I'm saying that initially it was rejected.
Yes, sir.
Prayer for maintenance was rejected under 125(4).
Yes.
You have submitted. And that against that order, they have preferred a revision petition, and the revisional court passed the order directing the trial court to decide the quantum. Now, my question is that whether in that other regards, is there any observation of the revisional court regarding 125(4) on the basis of which it was rejected earlier?
I guess there is no such observation, I suppose, Lordship.
paragraph 14 of page 69.
Paragraph?
Paragraph 14, page 69, Lordship. The sole ground that Lana JMFT has dissented on the petitioner that I failed to prove that she had left the respondent husband and matrimonial who refused to live with her without having sufficient cause. And paragraph 14 the ground.
This is the order of revisional.
Revision, Lordship.
So there is an observation. That
Yes, sorry. 13, 14.
Yes, then quantum was asked to decide.
Yes, Lordship.
Yes, and then
That therefore, Lordship, that impugn order which Lana has achieved before this honorable court is against the quantum of only the quantum.
now your challenge is only quantum.
Quantum as well as
Quantum as well as that or earlier order, the order passed by the honorable revisional court. But while issuing notice from this honorable court, court has issued state the really decrease the quantum to 6,000.
That was an interim.
As an interim measure.
By this court.
By this
So
court.
that is different.
That is different.
That,
Yes.
that will come later on. Now question is that you are challenging the quantum.
I am challenging Lordship the quantum as well as the order passed by the honorable revisional court. Both the court orders are interim orders. My sole submission, Lordship, let the matter fix for hearing, Lordship, and a date fix as my learned friend agrees.
We are not prepared today.
No, Lordship, I am not well prepared, Lordship, because I was stuck in some other works, Lordship. That's why.
I was supposed to dispose of the matter today. Anyway. Is
Sorry,
there any
Lordship.
stage operating? No.
Stay there is
Because,
covered.
no, not stay technically, but
But some reduction amount. And the area amount is
And
still
Lordship,
paid.
my response submission was that there is a matrimonial suit is also pending and review proceeding also. Review proceeding is at the verse of end. DW has been last one DW is remaining for prosecution, and then a matrimonial suit from last as told to me by my client that almost for last 6 months the petitioner hearing was not cross-examined. So, and there some a top of conversation also going on between the parties with regard to the quantum of the alimony. And if that was settled, then Lordship, she undertakes to withdraw all the cases. That is also another procedure, but that is not on record, so I cannot say that at this point of time.
when the other matter is fixed, can you tell us?
13/5.
1-3.
Yes, on 13/5, it was fixed.
Let some days matter be our matter be fixed some days later to I mean subsequent.
If any outcomes comes,
if any outcome you can.
Because my submission, she is claiming around 50 lakhs, and he is not willing to pay that much amount. He is willing to 6 to 7 lakhs. Up to that, he was ready to pay. But he has other loans and other things. So the amount was not decided, so they could not come to an amicable settlement. That is the difficulty.
So what do you suggest? This should become in the hearing column or in admission column? I suggest that let it be on admission column itself. Right? I request. Your matter is on 13/5, so we will see some subsequent. 28/5 will do. 28. Try to submit if there is any development.
Yes, definitely, definitely. If there is any settlement alive, I will ask them to give me a copy of that settlement deed, or they normally it was agreed. And my learned friend also take necessary instruction.
Good only if it is.
Yes, maybe family matters. If it is comes to an amicable settlement, it is good for us also.
Welcome that.
Yes, it is good for us also.
We are always ready.
Then both party are in the win-win situation. Then the hatred will be
rather than divorce. We welcome most if reconciliation is there.
Yes,
that is most welcoming part for us. But anyway, what? Okay. Well. Yes.
May I please note
what was the delay?
We have taken steps upon opposite party. Records may.
Yes. You are CBI, na?
Yes.
Report आया है नहीं. We have not received the neither the AD nor the answer notice. We have to, most probably it has to be awaited. It is 2-5 order. Okay. You are MS?
P. Majumdar on behalf of M. Kumar.
T. Mujumdar.
P. Majumdar.
Third MS P. Mujumdar appearing on MS M. Kumar, the standing counsel CBI for the petitioner. ये तो नाम है सर. दिसे नहीं. नाम है SK person. Oh, लेकिन for office note dated 2/5/2026, the neither the AD card nor answer notice is returned to the consent section. However, it is seen that names of 2 advocates are being reflected in the cause list. Though there is no such office note in regards to filing of any Vakaratnama or appearance of counsels. Let the matter be accordingly listed after 2 weeks as on a date to be fixed by the registry, awaiting service of notice on respondent. Formally.
Your Lordship, on the last occasion,
Oh, my. Oh, take. Yes, 38, what is the position?
Lordship, the written objection was to be filed by.
Lordship, in fact, Lordship, the petition was misplaced somehow from our office. So that day I was supposed to get an extra copy of the petition from the other side that I didn't get. That's why I couldn't file the objection on time.
Do you have
So I apologize
today
for
with
that.
you?
Can I get an extra copy, Lordship?
Yes, Mr. Counsel, do you have?
We'll serve an extra copy today.
You can serve today.
Yes.
Otherwise, you have submitted already? Your-
They have appeared, Lordship.
No,
It's a box
appeared.
matter.
Do you want to submit any your written objection? Your oral submission will be okay. But you are Mr. A. Atri.
Yes.
Heard Mr. A. Atri did not counsel for the appellant applicant, and also heard MSSH for the learned additional BP appearing on behalf of state respondent. And Mr. E. Khan, the learned counsel appearing respond number. It is submitted by MS Bora that they are supposed to file their written objection today. But as the copy of the appeal is been misplaced, a copy of the interlocutory application has been misplaced, will not file the written objection in connection with IA criminal 997 only. In view of this, the applicant's applicant is hereby directed to furnish a copy of interlocutory application to the state respondent, enabling them to file their written objection on or before the next hearing. Yes, how many weeks you need, Bora?
Lordship,
How many weeks?
2 weeks time may be given, Lordship.
2nd of June.
Authorized, Lordship. High Court.
But for just some time can be possible, Lordship.
Passover will not be.
Fix it on some other day, Lordship.
Sorry for condemnation of delay, Lordship.
Condonation only. What is the delay?
Delay is a
551 days, Lordship.
551.
Yes.
so petitioner had some medical procedure, surgeries and all, then this area where he resides,
30,
election was
40, 50,
conducted.
60 is okay. We can pass the order instantly, but 555 is quite a long delay.
Lordship, relevant paragraph is paragraph number 4, Lordship, page 7. On medical grounds.
Medical.
Seven,
It is some order is under challenge.
Yes, Lordship, the order of Zimma, there is a misinterpretation by the learned trial court, Lordship.
So you have challenging the order of Jimba.
Yes, Lordship.
And it took 555 days.
Yes,
51
Lordship.
days.
Actually, he came approached us quite late after passing of the judgment of the learned trial court. The reason is that we have stated in
Their
para
ground is on which para?
4, Lordship.
Paragraph 4, page 7.
Para 4 and 5, Lordship, page 7 to 9, Lordship.
You're saying for 2 years he is in almost
Yes.
about 2 years he was in treatment, but you have not stated anything regarding his
So the
diagnosis.
problem is, yes, Lordship, these are,
Undergoing blood test, under diagnosis,
yes,
regular medication, but what kind of thing he was suffering from?
Yes, any supporting documents.
I mean, for quite a considerable period, na?
That-
More than
that-
1 year.
that I admit, Lordship, but the problem is,
Medical treatment, there are serious illness. But is there any diagnosis?
there has been reports, Lordship, but the problem is we can produce case details in the area where he resides. There had undergone eviction and demolition drives and eviction drives in the area where he resides. So because of
No,
that,
no, at the
Lordship,
time
many
of
of his,
institution, you did not file anything.
Lordship,
It may be under a demolition drive, but it now
because
you
of
do
that
not, you,
reason,
you don't
Lordship,
have anything.
because of that
So
reason,
what,
Lordship, is
I
that,
mean, your diagnosis, you were diagnosed with some
yes, Lordship,
disease, na?
yes, Lordship, yes.
But that is not there.
That is what I'm saying, Lordship. Many documents are misplaced because of those demolition drives.
Okay, then let me become
Yes, Lordship.
for the
Next week, Lordship, immediately.
next week we cannot give. Eighteenth of May.
Much over.
The request for it. The criminal petition, or you have filed by you. So you have already appeared.
Yes, ma'am.
It's what, against acquittal?
Against acquittal, Lordship.
Yes. Where is the petition?
In the Lordship. IA is also there.
Yes. I is for what?
For suspension, Lordship. IA is for one delay, Lordship.
Huh?
680 days delay.
Or the delay was there, no?
Delay.
680 days.
Lordship.
My lord, in leave petition, I have no objection, but in IA, my lord, I think delay is long and no merit of the case also. So my learned friend is filed, my lord, that
But
I
it
was
is-
acquitted. But regarding the dispute of age, but as per the admit card, she was found major.
No, these are come on merit. I'm not on, we are not on that. Where leave petition is
In page
there
number
as well
5.
as the, your
Yes, ma'am.
condemnation is there.
Yes.
So
Lordship,
condemnation, yes.
Paragraph 5 is also there in page 4. Paragraph 5 is there, Lordship. Lordship, in these cases, we have to follow the procedures, Lordship. So it takes time, Lordship. Paragraph 4 is also there, Lordship.
It was a 6 POCSO.
Lordship.
No, see, it is basically there are some official correspondence.
Lordship.
Obviously, we can also see that there, due to this communication and
Lordship,
official
time,
correspondence,
Lord.
it takes some time.
Time, Lordship.
That may be one of the. Would
And regarding this, Lordship, deliberate discussions also need to be there. That is why, Lordship, all this takes time. Deliberate discussions also took place, Lordship, on this regard. So, and many to and fro, Lordship, communications are also going on. It is because of that we take time, Lordship. We need time. So kindly grant us, Lordship, delay may be condoned. It's not.
That's right, ma'am. Yes, ma'am.
Lordship. Before you open, mm, Lordship. Lordship. For this control.
Oh.
Yes.
May I please your lordship? This is an appeal against conviction, my lord, under section 8 of POSCO Act, my lord. Yes, my lord. Yes, my lord. Notice already served, my lord.
Notice served. Notice served. Already served. The amicus may be appointed, Lord.
Lordship may fix a short date, my lord, amicus may be, because this is conviction of 5 years only, my lord, and objection is not required, my lord. Objection from the state is not required, my lord. Only 5 years. Not required, my lord. Only 5 years, my lord. POXO 8, my lord.
Lordship.
My lord, can be on 11th, my lord, Monday. Because only
We have served, we have received report, Lord. We have received report.
my lord can be on 13th there, my lord, kindly, my lord. This has been pending for long, my lord. Humble prayer, my lord. 13, my lord. Kindly, my lord. 14. My lord, 26 will be very long, my lord. Can it be? Oh, sorry. Sorry. Can it be 14, my lord? 14? 15, my lord. Obligation. Deeply obliged.
May it please your lordship. No, my lord. 42B. 20B NDPS Act.
NDPS, Lord.
Yes, my lord. 7 years imprisonment, statutory appeal, my lord. Delay was there, it has already been condoned. TCR is there. Main accused person has already been enlarged on bail, my lord. My lord, in this particular case, my lord, if my lordship may can execution of sentence and stay of realization of fine, my lord, that my lordship can decide, my lord. There, my lord, that order has already been passed, my lord, in that case. It will be optional. I is there, my lord. I have filed. My lordship. My lordship. My lordship. My lordship. Yes, my lord. My lord. Yes. Yes, my lord. My lord. I is there, my
My lordship, 22nd. But, my lordship. My lordship, because my lord, on the last occasion also this matter was listed and one query was arised, my lord. The other appeal, my lord, it has been shown as part heard, my lord, in one of the order. And my lord, the appeal was about to be listed on month of January, my lord. So, my lord, this January, my lord, release this matter on 21st January 2026 for hearing as part heard, my lord. A order of 8/1/2026, my lord. So, part heard, my lord. After that, no order is there, my lord. Oh, okay.
For 3 months. Partner will only for 3 months, lordship. It will already been released.
After that, my lord, 10/2/2026, this order was passed. By the same court, same court. So I think, my lord, this order by now it has lost this, my lord. Yes, my lord. And that earlier order, he took part heard order. But my lord,
Better lordship.
but my lord, my lordship, my lordship. That part, the is also part heard, my lord. It was prior, my lord. This order is subsequent. Part heard order is prior, my lord. 8/1/2026. It has given list this matter 21st January. The order was passed in appeal. Appeal. I disposed of on February. This order is of January, my lord. Oh, appeal. It is January order. This is IA, my lord. This has been disposed of, my lord. Disposed of. Prior order, earlier order, my lord. এই order to দেখাই দিয়ক না এবাৰ। এই order to দেখাই দিয়ক। নহয়, তাতে নল'ব পাৰে। It's my duty to inform this honorable court. I am, yes, my lord. My lord. My lord. My lord. Because, my lord, I cannot pray that this matter should be listed before appropriate bench, my lord. Because appeal number, my lord, 42/2025. Yes, my lord. Criminal appeal 42/2025. Because this is 7 years imprisonment, my lord. So it may come up before any bench, my lord. My lord. My lord. Release me. Kept as part heard, my lord. Yes. But this order subsequently passed. My lord.
All sides.
My lord. My lord. My lord.
Tag, it will be tagged.
Tag.
Oh, lordship, it
My
may
lord.
be done. Lord,
My lord. Itu naik. But my lord, Both the cases together, right? But what? Wait, my lord. Then my lordship can take up this IA today, my. Was it?
Or we have.
My lordship.
Partner according to us.
My lord.
But the question is that it was not there, if no such kind of order was there. So automatically.
এটা দেখুৱা নাই নেকি? হা? My lordship. Last order to what number? Itu kisah order to what last? Kami muka order number kita pak. Because of this. My lord. Good. My lord.
Partner order again passed on this 21. It's simply misleading.
My lord. But both the cases have been tagged together. So my lord. Itu. On the last occasion also this confusion was there, my lord. And even my lord, this part hard chapter, my lord, even we are confused, but that is why, my lord, as my duty, my lord, I am putting it, my lord. My lordship, because my lord, some accommodation, my lord. It's already, my lord,
Second opportunity hearing is so there.
2.5 years, my lord.
Or rather. If it's in a.
My lord.
So that it can be hard. That's why my.
My lord.
So rather than 27 members, second is there, you fix it.
My lord.
Then it.
My lord, is it possible any prior date, my lord? This month only, my lord. At 2, my lord. The 2 years, 6 months, 19 days, my lord. 7 years, my lord. My lord. My lord. My lord. Can you kindly take observation? I will be, my lord. I, my lord, that part. For consideration of I, my lord, limited. Deeply observed. My lord, deeply observed.
We have already taken steps, Lordship. H. Mujumdar, Lordship.
May I refer? Lordship, in this case, small correction is not. Lordship, by this order dated 17 to 2026, Lordship allowed the petitioner to appear before the trial court, Lordship, with some liberty, Lordship. Page 8 is the. But in Lordship, but in this order, Lordship, the trial court sessions case number is not mentioned. That's why, Lordship, he could not appear, Lordship. He prepared, but here it is simply mentioned, Lordship, in second para, Lordship. This is an application in the session status also. Praying for setting aside the order of issuance of NPW dated and subsequent order dated passed by the learned additional session judge Steve member. In here, Lordship, sessions case number is required. Lordship. Otherwise, but nowhere it is mentioned. Lord, no, no, Lordship. I have submitted this IA filed on 2nd of March, Lord. But on 2 occasions I have mentioned, Lordship, but it was not listed. March, Lord. Within 15 days I have mentioned. The affidavit is also mentioned in 2nd of March. The affidavit is mentioned. AMS Majumdar. AMS Majumdar.
It's an application for correction of the inadvertent rectification of the order dated 17/2/2026 by this court in criminal petition number 217 of 26. Next right is submitted by Mr. Majumdar that the order dated 17/2/2026. The present petitioner was directed to appear before the learned trial court below. Below. An appropriate application for bail which may be considered in accordance with. He was directed to appear within 15 days from the date of. Accordingly, the petitioner tried to appear before the learned trial court below. But as the case number was not reflected in the order, the petitioner could not appear before the court to file the appropriate application. Thereafter, on the 3rd of March, the petitioner instituted this present present interlocutory application, but it was not listed and listed earlier. Mr. Majumdar accordingly submitted that due to non-mentioning of the case number, the petitioner is not in a position to appear before the learned trial court. And accordingly, by the instant petition is prayed for some correction to the modification of the order by this court dated 17/2026 in criminal petition number 217 of the 26. Mr. Das, Ilan Additional PP, raised no objection to that. Next paragraph, considering the submission made by Mr. Mojumdar, that the order dated 17/2/2026, passed in criminal petition number 17 of 2026, be rectified to the extent by inserting the case number in
Second paragraph.
para 2 of the said order, and
After words Shivumi,
that's in, after the word Shivumi, inserting in sessions case number, na?
yes, Lord.
What is the number?
That's one case number 86/2028, 18
Sessions case number 86
of the 2018.
verify forward. Collected verify আছে নে নাই? তেতিয়া আগৰ criminal petition
The prayer it is mentioned clear. The call title of the room.
posted. Yes.
Page 2.
In sessions case number 86 of the working out. Okay, we are
Okay,
within
in
15 days on.
15 days from today. Of that.
It order 15 days before midnight for that. 15 days before.
Made please your lordship. Madam, this is for quashing of the POCSO case number 19 of the 2026. Madam, the notice was issued and my learned friend appeared for the respondent number 2, victim, my lord. My lord, in this case, my lord, the petitioner number 1 and the my lord victim are my lord, they are
The opposite party number 2, that is the wife, my lord. This honorable court, my lord, it was my lord's order only, that 2 and 3 for the father of the, it was state, my lord. My lord,
So you have not taken steps.
my steps I have taken, my lord. 498A case was also instituted against us, my lord, by the same opposite party too, my lord. There, my lord, there is a subsequent development, my lord. May I kindly hand over the order of this coordinate bench, my lord? Coordinate bench of this honorable court, my lord. May I kindly? My lord, the same opposite party number 2, my lord, had instituted a 498A case that was also reflected in the last order passed by my lord. That has been stayed by the honorable coordinate bench of this court. My prayer is same, my lord. For the petitioner number 1, my lord, if the matter could be stayed, my lord, because, my lord, there is only one ground. In this DV case, my lord, for which I have come, they are seeking monetary compensation also. If the matter is not stayed today, my lord, I have to pay, they have asked for hefty amount, my lord, 40,000, 10,000 monthly, my lord. That is why
my view is different. I'm not going to stay in DV or maintenance in any point of time. Your parents was there, so that's what that the order was passed in regards to your 2 and 3.
my lord,
We are not going to pass any stay.
last submission, may I-
So you have taken steps or not yet?
steps taken. Perhaps
Steps
not,
taken.
perhaps not reached. My lord, may I make one last submission? One last submission. My lord, that case, my lord, the similar case, my lord. That basis was also the FIR, my lord. One FIR was filed, out of which the 498A case was registered. That FIR is itself frivolous, my lord. Because
We are not on that. We are not going to pass any stay order on the against the husband.
my lord,
That's
my lord.
coordinate bench may pass.
Yes,
I am not.
yes.
We are not on that.
My lord, my lord, my lord.
Heard Mr. P.R. Sharma, the learned counsel for the petition. Also heard. State is a formal party. Also heard Mr. K. Raj, the learned additional PP appearing for the state respondent. From the office note dated 5/5/2026, it is seen that is both service report and the TCR is still awaited. Let the service report and TCR be awaited till next date of the listing. However, the registry is hereby directed to issue reminder for the TCR to the learned tribe. List accordingly.
My lord, interim order passed earlier to continue.
Yes, interim order passed earlier for the respondent for the petition number 2 and 3. We continue till next date. Okay.
I'm so obliged, my lord.
It at least to get approved. After 2 weeks later. After 2 weeks. Yes, one this criminal appeal is there along with one I is also. The I is for suspension.
Lordship, matter may be taken any some other day, as my senior ISIK has already left due to summer.
I Sakia was there. Yes, Ms. Begum, it's okay. Yes. At a request made by Learned.
Kindly a date may be.
Appellant. With the consent, no, with the consent of the Learned Counsel for the appellant, require I to prayer act. Yes, what do you want to submit?
Kindly a date may be.
It will be listed on 4th of June, hearing day.